saith, Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. Good morning, everyone. Welcome to the Appeals Court. I'm Justice Rubin. I am lucky, and you are lucky, because I'm joined today by my two excellent colleagues, Judges Desmond and Englander. We are, of course, holding argument by video conference rather than in person due to the ongoing pandemic. The rules for argument by video conference remain the same as those rules that we have in the courtroom. It's 15 minutes per side, and there is no rebuttal. We have read your briefs with care and are familiar with the facts of the case, so my recommendation would be to get straight into your argument rather than taking time on reciting the facts, but the time is yours and you may do with it as you will. We will hear first in this case, well, the first case is 19-1299, Commonwealth versus Leck, and we will hear first from Attorney Opperman.
Good morning, and may it please the court. My name is Erin Opperman, and I represent the appellate defendant, Mr. Lang Leck. We are here because of two main errors in the case below. The first is the erroneous denial of the defendant's motion to suppress, and the second is an error creating a substantial risk of miscarriage of justice during the prosecutor's closing. To begin with, the motion judge erred in denying Mr. Lake's motion to suppress because it was clear that Detective Sandoval initiated and carried out a search of the vehicle Mr. Lake was driving with an investigatory intent and an investigatory objective, and there was no other justification for the search of his car. The judge below did in fact find that Mr. Lake was stopped.
So can I just stop you right there? I certainly understand the basis for the statement you just made, but it does not seem to me to be consistent with what the judge found. I'm on page 146 of the transcript. I find that the inventory was done pursuant to a fairly typical inventory policy after a decision had been made to tow the vehicle. How is that consistent with your statement that the only purpose for the search was an investigatory search?
The judge did find that the search was conducted pursuant to a fairly typical inventory search policy. However, the judge didn't actually and specifically address whether or not it was carried out with an investigatory objective. I think that the judge's findings are consistent with the appellant's, the issue that the appellant is raising, because the judge finds at motion to suppress transcript, page 56, that this was a pretextual stop. So essentially the judge agrees that when Detective Sandoval actually pulled over Mr. Leck's vehicle, that it was done with pretext. Between the time of the pulling over—
Does it follow from the fact that it was a pretextual stop that the purpose of the search was investigatory? Because you have something that happens in between, right? Which is, it turns out your client doesn't have a license and is driving a vehicle without a license.
That is correct. And I do believe it follows in this specific case based on the facts of this case. And the facts support that the intent to search was investigatory are that before following and pulling over Mr. Leck's vehicle, Detective Sandoval testified that he was out patrolling a specific area of Lowell with the sole purpose of looking for motor vehicle stops to effect gang suppression in the area. That was his intent when he was looking for motor vehicle stops, and that was his intent, as the judge found, when he actually pulled Mr. Leck's vehicle over. He further testified that when he approached Mr. Leck, before he realized that there was an arrestable offense, he testified that he in fact believed that he had pulled over a gang member. He testified that based on what Mr. Leck looked like,
He pulled over a gang member who had engaged in, and I believe it's uncontested, a traffic violation. Let me ask you another question. Are you arguing to us that the Lowell policy is unconstitutional? The policy that was testified to is itself unconstitutional?
Under current Massachusetts law, I do not believe that the policy of effectuating pretextual stops is unconstitutional.
Is there any case that's ever addressed a policy that is as broad as this one? I mean, it's one thing to say, I was following a drug dealer because I thought he might have drugs in his car, and then I saw him, not signal his right turn, and I pulled him over. It's another thing to say, I'm sending my police officers out into the neighborhood to conduct whatever stops they want of gang members. Is there any case that we have that addresses a policy as broad as that?
I do think that the recent case of Commonwealth versus Buckley touches on it slightly. I do believe that the Lowell policy is unconstitutional. I don't necessarily believe that the facts supporting that claim were sufficiently sussed out in the motion hearing below. I believe that such a policy as this is likely unconstitutional because the breadth of the policy will really necessarily result in the overstopping and arrest of racial minorities. And that is what in fact happened in this case, though again, it wasn't raised by Mr. Leck's lawyer below.
Well,
So Sandoval,
sorry, Ken.
go ahead, I just want to jump in here for a minute. So Sandoval testifies that they're out investigating gang activity. Being a member of a gang in and of itself is not illegal, is that right?
That is right.
All right, and so the stop that they made, it wasn't for running a stop sign, it was failing to come to a complete stop at the stop line of an intersection, is that right?
That's right.
The officer waited a half a mile before they waited to pull the vehicle over, is that right?
Yes.
And when they pulled the vehicle over, they decided when to activate the lights and where actually to pull the vehicle over. Is that fair to say?
Of course, yes.
All right, and so then he recognizes that this person is dressed in all red and appears consistent clothing with what he believes to be gang member.
Yes.
Now, the only reason they're stopping gang members is because they think that gang members are engaged in gang activity. Is that right?
That's true.
So how do you get around that they're investigating gang activity?
How do I get around it?
That's my question. Is there any way to get around it?
I just want to make sure I understand your question. Are you asking about whether or not that is legal to just make motor vehicle stops based on a suspicion that someone is a gang member?
That's the question.
Well, in this case, I think that the Massachusetts case law is certainly different when it comes to whether or not it's legal to stop someone because you suspect they're a gang member when they have in fact committed a motor vehicle stop, which the judge found here. I disagree with the current state of the law, but I believe that is under the current state of the law legal.
Well, gang members don't get any special exception. I mean, anybody can get stopped if they're observed committing a motor vehicle infraction, right?
Right. What I don't think is legal is using pretext to conduct an inventory search. And that is a really stark difference in Massachusetts, as obviously you know. You cannot stop someone for a motor vehicle stop, truly suspect they're engaged in criminal gang activity, get lucky in that they are without a license or with a suspended license, something that Detective Sandoval specifically said he looks for when effecting motor vehicle stops in hopes of stopping a gang member. He testified, I can give you the site, but I'm sure you've read the transcripts. He said, often gang members have revoked or suspended license. So what that tells us is that Detective Sandoval not only is looking for motor vehicle stops as pretext to stop who he believes are gang members, but he's stopping them because he thinks there's a decent chance that they'll be arrestable. And he knows that if they are arrested, he can then conduct an inventory search. And it is that part of the policy that is unconstitutional.
But in this case, he had no way of knowing that the operator of the vehicle, or he didn't testify anyhow, that he believed when he stopped the car that it was necessarily a gang member. He didn't see the driver. He didn't see what the driver was wearing. He didn't know what the operator looked like.
He did testify that when he approached the window before there was
After
any
the stop, that's after the stop though, right?
Yes, after the stop. And it is the appellant's argument that even if this court found that he had an investigatory intent when he began to follow Mr. Leck, that he momentarily lost that investigatory intent when he realized that the registered owner was not known to him, that he did in fact pick back up that investigatory intent when he saw what Mr. Leck looked like. And that he never lost that investigatory intent when he—
What is this investigatory? So unfortunately, we have no findings from the judge on this subject. And I don't think, I think certainly these issues were before him. And I've read you the only piece that I found that really addresses this precise issue. What was the intent? But when you say he had an investigatory intent, he had an intent to stop gang members, right?
Right. I think it's clear from his testimony.
And he says one of the things I know is it's more frequent that the gang members will be driving without a license, which is a violation of Massachusetts law. Actually, could be a serious violation of Massachusetts law, right?
Right.
I think is it unlawful for him to reach the conclusion that based on apparently a policy testified to, that the Lowell Police Department is going to look for gang members because we know that they're engaged in certain types of crimes? Is that unlawful?
Yes, I do. I do think that it's unlawful. What I don't think is lawful is justifying the search of a vehicle when someone is stopped and pulled out of their vehicle in whole or in part pursuant to that policy. I do not think that it's lawful to justify the search of a car based on an inventory search.
And this all turns on the law that the subjective intent with which an inventory search is done is relevant.
Yes.
Because it seems as though under current law, the intent with which pulling someone over, well, actually, I don't know about that, is not relevant. I mean, I know that, at least under current law, notwithstanding Justice Budd's concurrence in that recent decision from the SJC, the Fourth Amendment, at least, and the search and seizure provisions of the state constitution don't prohibit racially motivated traffic stops. This is a little different. This is, it's just a pretext. We decide, I'll ask your brother how they decide, but we decide who to investigate, and then we follow them until they commit. This is what the dissent was concerned with in Wren. We follow them until they violate the law, as everyone inevitably does driving a car, and then we pull them over. Do we know if that's lawful?
I think in many ways the SJC has decided that is lawful. I do think that particular finding has already begun to be walked back. I think that it is clear the SJC takes very seriously blanket policies in stopping and arresting individuals that will disproportionately impact racial minorities.
But there's nothing in the record. Is the race of the defendant even in the record?
Yes, it is. And he is a racial minority. He is Asian American.
And do you think the Commonwealth has a burden to demonstrate that what it did is not based on race?
I think what the Commonwealth had the burden of doing, and they did not do, is proving by clear and convincing evidence that Detective Sandoval did not harbor, and this is what the case law says, did not harbor an investigatory intent when conducting an inventory search. And I think the totality of the circumstances of the search in this case, where he testified that it was within his discretion to offer Mr. Leck an alternative He chose not to when he knew the registered owner lived in Lowell, was someone Mr. Leck had the contact information for, his girlfriend, chose not to call her. The way he pulled Mr. Leck out of the car, didn't arrest him, didn't tell him the car was going to be towed. Mr. Leck didn't even necessarily know the car was going to be towed or searched until the search was happening. He was sat on the curb, and by all appearances, he had no idea that he could request the police call his girlfriend to come get her car. All of those things in the totality of the circumstances in this particular case reveal strongly that what Detective Sandoval wanted to do in this situation was search that car.
Do we know
why?
I'm sorry, go ahead.
He testified himself, that's why he followed the car. And he testified also that his suspicions were confirmed when he saw what Mr.
Wait, he testified that he wanted to search the car?
No, he testified that he wanted to find gang activity when he was patrolling the area. And he testified after he did in fact arrest Mr. Leck, that he specifically did not give Mr. Leck Miranda warnings because he wanted to, quote, continue his investigation and ask Mr. Leck about his gang affiliation, his purpose for possessing a gun.
That was after he'd already figured out that he had an arrestable offense. He had someone who had no license, right? Let me ask you a question. Suppose we agree with you that the record that the judge created, his findings are insufficient on the question of the intent of the officer under existing law. What should we do? Because I think you want us to just say motion suppress should have been granted. But that seems to me like you're asking us to substitute a finding that wasn't made.
I understand Your Honor's question. I think it's a valid question. And I think in this situation, this court can very easily and properly find that if someone is pulled over pursuant to this policy the Lowell Police Department has, which is a policy looking for motor vehicle infractions to investigate criminal activity, that the Commonwealth needs to prove that any inventory search conducted after a stop pursuant to that policy needs to be proved by clear and convincing evidence to not have been undertaken for an investigatory purpose.
I understand that point. Thank you.
And remand for further findings on that specific issue.
Okay. We understand your argument. Thank you very much.
Thank you.
We will hear now from you, Attorney Lee.
Good morning, Your Honors. My name is Chi Lee, Assistant District Attorney for Middlesex on behalf of the Commonwealth. The impoundment here was for legitimate and non-investigative purpose after the defendant was stopped for a stop sign violation and refused to identify himself, which made him arrestable. The defendant did not have a driver's license. He did not have registered to the vehicle, and the car was stopped at a place where parking was not allowed. Therefore, the impoundment was legitimate and reasonably necessary. My sister
argued the policy of the Lowell Police Department is constitutional, and why?
So the police policy, it was unspoken policy. There was no evidence at the motion hearing that it was a written or concrete policy, but it was an unspoken policy that the police did follow that. It was
spoken enough so that the person who conducted the stop was able to testify that that was the policy under which he was conducting himself.
And that's correct, Your Honor, but my point is there was no written
no one has contested up till now that in fact was accurate testimony, right?
Correct. That's
okay,
correct, Your
so
Honor.
let's assume, because that's the only evidence we have of the record, that that was a Lowell policy. And I can't accept your notion that it was an unspoken policy because it's at least on the record as spoken. What you mean is it's unwritten.
Correct, Your Honor.
Does it matter if it was written or not?
It was not written, Your Honor. I'm sorry, I misspoke. My point is it was not a written policy.
Does that make a difference?
No, Your Honor. I just want to clarify for the record. But the policy itself is constitutional because the fact that the only case law that's out there that's saying all pretextual stop or pretextual stop or stop that's not based on protected class.
The officer making his decision
in this case
he was going to pull over for traffic violations under this policy.
So the policy that the detective testified to was in the gang unit that used traffic stop to come to patrol the area, and they used that to investigate. He also testified it's not only for it's not only for gang suppression. Sometimes they go out to take notes what the gang members were doing. They don't necessarily stop them or talk to them every single time, but it's one of the techniques they use to stop or suppress gang activity.
But Judge Englander has asked,
yes.
maybe you can tell us in this case, if we know, how does the officer choose which car to follow to wait until it violates a traffic law? How does the officer under this policy decide which cars to look at?
So in this case, the officer did testify he had a general intent that on that day his assignment was to find traffic violation to suppress gang activity. But
So
he also
decide which cars to stop.
Right. So the record does not show how he decided that. But
Is
the
it
record
your burden once we have a policy like this, with the obvious, it seems to me, risk of that my brothers have spoken about, the obvious risk that this will just be used for racial reasons, or that race will be used as a proxy for gang membership? Is the burden on the Commonwealth to show that there's some objective criteria other than race that's being utilized by the officers who are exercising discretion to decide which cars to stop and which ones not for traffic violations?
If it's based on a racial argument, yes, the Commonwealth has the burden to show that the policy is constitutional. However, on its face, the policy itself is not constitutional. There's no racial or protected class that's being calculated in that policy. And the only case law that's out there that would make this policy unconstitutional is Justice Spott's concurrence in Condon v. Long.
No, I hear what you're saying, but I got to tell you, this is a problem. The one we're talking about now, which isn't, it's here, it's in the case, but it's not really fleshed out. It's a problem that goes back decades in this country. There's a case called Colender against Lawson that U.S. Supreme Court decided a long time ago, a person of color walking through a white neighborhood. They decided the loitering law was unconstitutional because it was being applied in a discretionary fashion. And that's what we're confronted with here, it seems to me. We're confronted with a policy that is potentially incredibly invasive of persons' individual rights. And we don't know what the basis is on which it's being applied. Isn't that
I understand this policy could lead to the result that Justice Spott was concerned about. But in this specific case, the defendant was not stopped because of his race or other protected class reasons.
Don't you maybe have to have put in evidence of that? That is, once we hear about a policy like this, I know this wasn't exactly litigated this way, but once a court hears that there's this discretionary policy, don't you think it's the Commonwealth's burden to show that they're utilizing something that isn't race to decide which car? Because how else are you going to do it? I mean, this officer didn't see the gang colors, but for some reason he pulled it over. What are the possible reasons? It's an Audi, so it's an expensive car. I don't know how old it is, et cetera, but it's an Audi. Is it that it's an Audi driven by a person of color? Is that why he chose it? I mean, I don't know. You see what I mean? I have no idea.
Yes, Your Honor, but the officer did testify candidly, and the motion to found the officer testified credibly that he did not see who was he did not see the driver. He did not know who's the registered owner. The reason he pulled over he stopped the car is because he made a traffic stop violation.
No. His testimony, as I understand it, is that he was choosing cars to focus on in order to suppress gang violence. That if it was some cars, I don't know which one, a Buick driven by an old white guy, he probably wasn't going to stop that one for crossing the stopping line, come to a full stop, but over the stop line, right? He chose this car for some reason that we don't know, consistent presumably with what he was doing that night, which is looking for gang members.
That was his general intent.
You see the young male?
So if he went to a high crime area, quote unquote, where there was known active gang activity to the police department and stopped all cars that committed an infraction, would that be unconstitutional?
No, Your Honor, because if there was a traffic violation, it was within the officer's discretion, was within his power to stop the drivers. And that's true in this case as well. He saw a traffic violation and he stopped that car.
What should we take from the fact that he waited a half mile before he stopped the car?
So the judge did credit that he was waiting for a safer place, that it would not impede the traffic, and that would have not safety concerns, so he can properly perform the stop.
Can I now pull you into the argument that your sister has made here? I assume you agree that he had an investigatory intent when he pulled over the car, because he was doing it for gang suppression. So although it may have been a lawful stop, his intent was not, he wasn't on traffic patrol. His intent was investigate gang-related activity. Do you agree with that?
I agree that when he saw the driver dressed in red,
I'm saying when he chose which car to pull over, he chose it with an investigatory purpose. I wonder if this is some gang-related thing, because I'm not pulling over every car. I'm trying to suppress gang activity.
I disagree, Your Honor, because the detective did testify that when he was asked whether he would consider the stop as a gang suppression activity, he would say no, because he did not know who the registered owner was.
Well, I don't know. How's he ever going to know that? I mean, every car he pulls over, until he looks at the license and registration, he's not going to know for sure. He's investigating. But all right, let me ask you a follow-up question, though. Assume we disagree with you and we think that there was an investigatory intent for the stop. Why doesn't that taint the inventory search?
So my sister's argument, I think, was pointed on the reply brief. Her point was it was pretext from the beginning to the end. However, she cites to Ortiz, where this was this court's opinion in 2015. In that case, the court focused on whether the only purpose for the inventory or the stop was pretextual. Here, it was not the only purpose. In Ortiz, it was a pre-arranged, pre-planned that to stop the vehicle. Here, the officer saw that there was stop sign violation. The defendant did not have a driver's license, which made him arrestable.
Wait. If there's no probable cause of a motor vehicle violation, you can't stop the car to begin with.
That's
so
correct.
The problem isn't the inventory search, right? The problem is the stop. I'm saying, as I understand it, an investigatorily motivated inventory search is not permissible. Now, you keep saying the only reason has to be investigatory, but it seems to me that that's never the only reason, because you can't impound a car for investigation. You have to have something else, in this case, an arrestable offense. And he did commit an arrestable offense. I'm assuming, I may be wrong, but I'm assuming that if that was all, that an investigatory intent will still invalidate even an otherwise justified inventory search. So why doesn't the initial investigative intent carry over to the search?
I think there are cases Commonwealth cited in its brief that just because the officer would suspect that this would lead to a criminal evidence, that does not transform into an investigatory purpose.
Of course.
And if that's the case, then that would invalidate a lot of the inventory search, simply because the police suspect that something might come out.
That's a little different. You pull someone over and you have to arrest them. And the car is on a highway. You have to tow it. And so you have to do an inventory search. You may well look in the car, see something in there and go like, there's going to be drugs in the trunk, whatever, right? I mean, there may be tip-offs to that. And so you suspect it. But the purpose of the search in the first place wasn't investigatory. This isn't merely suspecting. This is an investigatory operation at the outset. And I'm asking if if that taints the search, notwithstanding the arrestable offense?
No, Your Honor, because my argument would certainly be when the defendant was stopped and when he refused to identify himself, the officer would have no choice but to arrest him and then conduct an inventory because the car must be towed at that point.
Okay, now,
Whoa. You're
officer
moving too
chose-
quickly when you say that, okay?
okay, go ahead, I'm sorry.
I'm sorry, but there's an argument your sister has in the middle of that process that you just described. So, and it's different than what we've been talking about. And it's this: he knows he has to arrest him, but he doesn't know he has to inventory the car. He could find someone to take care of that car. All right. And your sister says, under the circumstances, he should have done that. And you say, oh, the cases don't require us to make a phone call, right?
Correct, Your Honor.
But the facts of this case, I find very troubling in that the officer was already searching the car before he had even thought about or communicated with anyone that he was going to do an inventory search, right?
Correct. And understand it would be better practice for the officer to told the driver that I'm about to tow the car, so I'm going to perform the inventory. But the policy and the case law does not require him to do that. And Goncalves-Mendez, which is applies only prospectively.
If the policy doesn't require him to do that?
The policy only requires them to notify an owner of the vehicle that the car will be towed and offer them.
Why? Why is that a line? I mean, if it's reasonable and easy enough to do it with the owner, how can it be unreasonable? I mean, I don't understand why it would be unreasonable to require them to, the city of Lowell admits it's no big deal to tell the driver. We do it whenever it's an owner. So why don't they have to do it whenever it's anybody?
Right, I understand. The policy is if an owner is arrested, they will have the obligation to inform that, and understand it would be better practice if the Lowell police could change their policy to apply to everyone. However, not following the better policy with better practice does not make it unconstitutional.
Well, Oliveira says the owner or the authorized driver. So do we know whether or not this defendant was an authorized driver? Doesn't he make some comment about, I thought maybe my girlfriend reported it stolen because I had been arguing with her?
Correct, but other than that, there's no evidence to show at the time whether the officer knew he was authorized driver. But Oliveira also pointed out that the officer have no obligation to locate the registered owner or to wait with the vehicle until the registered owner arrives.
Let me ask you this also. The owner has, or the operator under the case law, has a right to make a reasonable request. And if the request is, my passenger here can drive it home, that has to be honored, right?
Correct, Your Honor.
How can we say it's okay not to tell the owner it's being towed until after you do the search? Doesn't that give the police the ability to just undo that right that the SJC says the owner operator has? Don't we have to say, you have to tell the person?
Yes, and Oliveira or those line of cases, that's only when the passenger is on scene. Here, the defendant was not the owner of the vehicle. He was not the one on scene. And that's why
owner isn't the key for Oliveira. It's true he didn't have a passenger with him. But why don't the police always, and it's true that Oliveira only deals with if there's a passenger. It doesn't deal with anything else. I don't know what the rule would be if he said, but the next house is where the owner lives. I'm one house away, they should come out and get it, even though they're not a passenger. I don't know. Maybe that would be reasonable too.
Correct.
How can you check the reasonableness of the request if you don't give them an opportunity to make the request?
I see my time expires. I will have 2 points to respond. Thank you, Your Honor. My first point is that's a concern that SJC has, and then the adopted Chief Justice Gaines concurrence from Eddington in footnote 8 in Goncalves-Mendez that it is better practice for officers from that case they should advise whether the driver or the owner that the car will be towed unless you offer a practical alternative. However, not following a better practice does not make it invalid. And Goncalves-Mendez does not apply retroactively. My second point is, even if the defendant was offered an opportunity to make a request. The request would be, my girlfriend is a mile away, she can pick it up. But even when that happens, Oliveira is very clear, the officer did not need to be there until the registered owner is there. So even if he was offered the opportunity to make a request, it would not make a difference.
All right, well, here, more questions? Because we can, no.
I'm just struggling with the, I think you articulate the law, but you articulate it in a way that's troubling to me, because the touchstone for every single question in this area is reasonableness. And there's a question, is it reasonable for the guy to be, the officer, to be already searching the car before he's even told the person he's pulled over, look, I'm going to inventory your car, and allowed that person the opportunity to give a reasonable way that does not have to happen. And the way the officer articulates what he thinks the law is troubling to me. Well, I have the discretion not to do that, which I read to some degree as, I have the discretion to conduct the investigation I want to through an inventory search, which is not the purpose of an inventory search. In any event, that's my little speech. I apologize.
All right, very, very, someone else said.
And we are live.
Good morning, council.
Good
The
morning.
next case we are hearing is number 19-707, BONACETO versus Commonwealth. I am Justice Rubin. I'm joined today by Justices Desmond and Englander. We are hearing the case by video conference rather than in person due to the ongoing pandemic. The rules for argument are the same here as they are in our courtroom, which is to say 15 minutes per side with no rebuttal. If you don't feel you need your full 15 minutes, you needn't use it, but you may, of course. We have read your briefs and are familiar with the facts of the case. So you may want to just get right into your argument. However, the time is your own to do with as you wish. We will hear first from Attorney Shepard.
Good morning, Your Honors. I represent the petitioner, David BONACETO, and I realize you recognize there are two arguments here, as well as a jurisdictional question raised by the respondent. I would suggest I can start with argument one. In regards to that argument, there is no jurisdictional issue because the petitioner is not requesting any change or alteration in what the petitioner considers to be a preference of the use of reasonable degree of professional certainty, but rather if the petitioner were to succeed, would ask the court to just remand and have the particular expert testifying to that term define it in terms of what he means by it. That would be, so therefore, we're not asking for any alteration in regard to that particular one argument. And as to that argument, it's essentially indicating—
I thought I read your brief to suggest the contrary, that you wanted us to determine that the formulation reasonable degree of insert appropriate word, psychiatric certainty, I think in this case, is improper and should not be used in the courts of Massachusetts.
I actually presented that or intended that to be taken as a second argument, like in other words, one argument would be what I said, and the second argument would be that in any event, it should be abandoned.
Yes, I'm not trying to understand any of this as jurisdictional anyway. You can appeal, we have jurisdiction over an appeal, you can make whatever argument you want. You might lose or win, but you know, but
I don't think you should be concerned about a jurisdictional issue. It's an argument that you can present to the appeals court, even though the SJC has come out differently. And because it's in the appellate courts of Massachusetts appropriately under an appeal from a final judgment.
So
Okay.
to the extent that you make the second argument, then how are we to address the issue that you're raising, which essentially is that this language is language that should not be permitted. That's essentially what you're saying. Is that the crux of the argument?
Yes.
And the SJC has already determined that so far, so good with respect to that language.
What the petition is arguing basically is that it is not settled law, and that Patu Hang and any subsequent decisions that were cited in my brief relative to unpublished, that state acted as though it was law. In fact, we're simply taking dicta and making it as though it were a holding.
You call it dicta.
Yes.
But the SJC has said, I think it's actually said this is the preferred formulation. How can we undo that? I mean, they can undo that, of course, but how can we?
Because I think when they state it's preferred, they are not making it a required mandatory.
I understand your point is that it may not be the holding of that case. It may in some broad sense be obiter dicta. I get that. But they said it. What do you think they're going to do if we say that they weren't bright enough to say it in a case where it was a holding? I think they meant it, even though it may not be a holding. And sometimes they issue decisions where they say, even though this issue isn't squarely presented, we're going to reach it to give guidance to lower courts. And I mean, I understand we might have the power to do it, but isn't it, I mean, shouldn't you be asking the SJC rather than us, I guess is what I'm saying.
I think that is not necessarily the way that it would have, or that even it should be. I think that sometimes cases come before the appeals court that are similar in the sense of the SJC having made some sort of ruling, and the appeals court, I don't have one offhand that I can think of, frankly, but I do know they exist. The cases where the appeals court indicates that there should be some change, or sometimes they may refer it to the Supreme Judicial Court for them to decide.
We may indicate there may be some change, but I don't know that we can actually make the change. If the Supreme Court has said this is the preferred language and a party has relied on that language, how can it be fundamentally fair now to say, oh no, sorry, that was wrong?
Well, I would suggest you don't have to rely on that language. And I would suggest the Supreme Judicial Court didn't make that requirement when it set those guidelines.
They also didn't say, I understand what you're saying, but you're asking us to prohibit the use of that language. And they said it's the preferred language. Obviously, you can use something else that's non-preferred, but you're asking us to say that the preferred language is actually impermissible. And maybe it should be, but I just have a hard time seeing how we're going to be the ones to say that.
Can I ask a question that's a little unrelated, but what do you think the formulation should be? Let's assume you can't ask to a reasonable degree of, insert word, professional certainty. What should it be?
I would suggest it should be more likely than not, Your Honor. And I would suggest that because I think that term.
So in a criminal case, now you're going to limit the expert to just saying more likely than not under circumstances where the burden of proof is beyond a reasonable doubt. That seems to me to be a problem. He may hold the opinion with greater certainty than that.
I'm sorry, but could you just repeat that again? I apologize.
I mean, the suggestion that all you're going to allow an expert to say is that he holds an opinion more likely than not, it seems to me is a real problem for the prosecution if the expert holds the opinion more strongly than that, particularly in a criminal case where the burden of proof is beyond a reasonable doubt. If he says, well, I hold it more likely than not, and I'm defense counsel, I'm going to say, did you hear what their expert said? That didn't sound like beyond a reasonable doubt to me. All of these formulations are problematic. I've read the comment from the National Forensic Science Committee. I was aware of it before you made these arguments, and I understand it. But I'm quite serious in saying, if we were to do away with this formulation, what should that be? It seems to me there needs to be an answer to that.
There's one moment, please. I'm sorry. I just want to check something.
No problem.
I had there's a case that I didn't cite, but it's USB Flynn, and I'm just trying to find my I had it here. I'm sorry.
That's all right. What court is it from?
No, I should have it directly. Can't believe I did that. Well,
one of the problems of a Zoom hearing on your desk is that it's not so easy to spread out. Don't worry about it.
okay.
Whatever you can tell us would be helpful.
It's US v. Flynn, F-L-Y-N-N.
No. Really, no, I'm sorry. I had it right here, I thought, and it's well, here. It's USB Glynn, G-L-Y-N-N. It's 478 Federal Supplement 2nd, 567, 2008. It's actually from the U.S. District Court, New York. But it appears to be pretty much, that I can tell, discusses what you're directing your concerns to. It basically, I think what's going on is that it's problematic and it's difficult to come up with a term or a manner in which to gauge the admissibility of an expert's testimony in this situation, because it's somewhat subjective, because you're trying to admit evidence and do it in a manner that doesn't give the wrong impression to the jury, and simultaneously has to deal with some methodology that is not necessarily perfect. So to exclude, which is the intent here, I believe in the end, is to exclude unreliable testimony and ensure the jury knows the limitations of that testimony. I think that that's probably the goal that would want to be reached. And the rules of evidence in this case dealt with federal, but it's the same as the rules of evidence of Massachusetts 401. And basically it doesn't require that high level of certainty to have an expert's opinion admissible. The rule simply requires that something be more probable than not. I believe that rule applies to expert testimony whether or not it's civil or criminal. And so in order to the court here felt at least that if that the more likely than not standard didn't involve an overstatement of the certainty involved, and also, you know, dealt with the capacity, in a sense, of the methodology that's being used, which is largely dependent upon subjective experience and training.
So is your concern that the jurors either gave too much weight to that term? What, I mean, are you quarreling with the judge's instructions to the jury about that, about the expert testimony and the level of importance that the jurors should give it?
I think it leaves it open, if I understand what you're asking. I think it leaves it open for the jury to consider it to be an opinion that is beyond a reasonable doubt. And I would suggest there is another case, and again, it isn't cited.
But wasn't the judge's instructions in this case pretty clear that that wasn't what they're assigned to do?
The instructions dealt with the differences between the psychological aspect of this and the legal aspect of this, and clarified to some degree where the beyond a reasonable doubt stands within that. But it did not deal with the fact that an expert can have within the principle, the disciplinary principle that he's in, such as psychology, that person can't himself or herself intend the opinion as given couched in the terms of reasonable certainty to be beyond a reasonable doubt. So he or she can have that opinion and can convey that opinion. The jury can be misled into that because they're not given any definition. And that part of it is not covered in the jury instructions. The jury instructions don't cover specifically what the expert may mean.
Your time has expired, Attorney Shepard. I think we understand your argument. Thank you very much. A very helpful argument to us. We will hear from you, Attorney Mansfield.
Good morning, Your Honors. Brian Mansfield for the Commonwealth. As an initial matter, this case is being reviewed by this court for a risk of a substantial miscarriage of justice. This issue was not raised below. In fact, in Mr. Bonaceto's instructions to the jury, or request for instructions to the jury, he requested an instruction very similar to what the judge in fact gave, and that was that the experts would be testifying under the principles of psychology, and that the jury had a different task, and that was to find beyond a reasonable doubt. So again, this is not an issue that was preserved. As several of your honors have stated, the Commonwealth followed the preferred practice set forth by the Supreme Judicial Court. We cited the Hang case, which lists a number of different cases that say whether it's medical certainty, professional certainty, psychological certainty, and that's what the Commonwealth did. They offered their testimony to a professional, to a degree of professional certainty. I don't think the Hang case, that language was dicta. That case dealt with whether forensic ballistic testimony was admissible, and the court walked through what needed to be done to have that testimony be admissible, and their conclusion was that there had to be, the basis for that opinion had to be handed over in discovery. The witness had to describe the methodology he used and had to offer the opinion to a reasonable degree of certainty. They did say in that case, you don't want to use the word scientific certainty when it's a soft science like ballistics. Again, that's not what happened here. And they did say you don't want to give it.
Could this issue just be addressed by a jury instruction that actually gave a definition to a reasonable degree of certainty? In other words, when an expert uses the term reasonable degree of certainty, it means X.
I think that would be a slippery slope. That would be like saying more likely than not as to what it held. They do, I believe, that the instructions let the jury know that it's not beyond a reasonable degree of certainty, and they distinguish it from the burden that the Commonwealth has and what the jury has to find Mr. BONACETO sexually dangerous.
The issue that your sister raises is not, it's not coming out of the blue, right? You've got a number of courts that have had this problem. You have a national commission for all forensic science that has said our scientists should be advised not ever to use this formulation because of a concern that it doesn't have a definition. Also because of a concern that it's misleading. So I guess what I was looking for is whether there's, so I asked the question of your sister, is there some other formulation? I'm not sure that any of the cases suggest a different formulation. And so I was sort of asking a different question, which is, could we solve this by giving it a definition? You say that's a slippery slope. I'm not sure why.
Well, the issue was brought up as should it be more likely than not? And when the Commonwealth has the burden beyond a reasonable doubt to offer the opinion.
Well, no, but the court isn't going to say it means more likely than not. The court's going to give, it's going to have, you know, a judge has a paragraph that they can say, well, it's not beyond a reasonable doubt. It's not more likely than not. It's intended to give a degree of certainty so that you can rely on what the scientist says or something along those lines.
And the Commonwealth's position is that the instructions do just that, where they say that the experts are testifying to psychological principles and psychological standards and not to what the jury must find. So they're clearly distinguishing the two concepts that to a reasonable degree of professional certainty is not beyond a reasonable doubt.
What was the thing that was to a reasonable degree of professional certainty here? Dangerousness?
Sexual dangerousness, yes.
Sexual dangerousness to a reasonable degree of professional certainty. Okay, I mean, I don't know. It seems to me that if you're doing DNA testing and you say it's a match, a reasonable degree of professional certainty would be 1 in quadrillion, whatever. And if I say, oh, this gun has the same markings, you know, this bullet case has the same markings as this one, you know, maybe it's substantially less than that. Professional certainty can only get you to 30% sure or 50% sure. And yet we use the same formulation each time. That's an interesting question.
And again, based on the standard of review for this court and the fact that the Commonwealth relied on the SJC's preferred language. Now, there are cases that say that to a reasonable degree of certainty are not the magic words, but in those cases, the appeals were based on experts who offered their opinion, did not offer that opinion to the standard. And the question was, should they have been
excluded as a result?
Because they didn't bring it up to that certainty. And the case law said, well, you got to offer to some level of certainty. So again, the case law hasn't been, do you need to define it more, but, or should it be defined beyond that? But when the cases have not said that, it's, do they get close enough to that language by offering it in some degree of certainty?
I'm old enough, counsel, to recall a jury trial in the 1980s where I was examining a coroner and I left those magic words out and I got an objection. And the judge instructed me that I needed to include those words, or he was going to, or she in that case, was going to exclude the question and the answer. So I hear you.
Yeah, and that's what generally, and this was not such a case because Mr. BONACETO did not have any experts opining that he was not sexually dangerous. But when experts do offer that opinion, they also offer it to a reasonable degree of either psychological or more often professional certainty. So the experts who are retained by petitioners such as Mr. BONACETO, they're offering their opinions on the same basis. So it's generally been the practice in the SDP world for at least 20 years.
In this case, Mr. BONACETO didn't call any expert, is that right?
He did not. He did retain funds to hire experts, but he did not call them. So I think based on his history, it's clear that although he was reviewed by retained experts for him, they did not find him not sexually dangerous because he was awarded funds for 2 experts. And if there's no other questions, Your Honors, the Commonwealth will rest on their brief.
Thank you very much, Attorney Mansfield. Good morning, everyone. The next case we'll hear this morning is number 19-1746. I am Judge Rubin. I'm joined by Judges Desmond and Englander this morning. Welcome to the Appeals Court. We are self-evidently holding our argument by video conference rather than live and in person due to the ongoing pandemic. The rules of argument remain the same, which is to say it's 15 minutes per side and there is no rebuttal. We have read your briefs and are familiar with the facts, so you may want to just get into your arguments, although it is your time to use as you wish. We will hear first from Attorney Curran.
Good morning. May it please the court, Dana Curhan for Mr. ADAMES-GARCIA. The jury in this case deliberated for 5 days, and after 4 days, they came back with not guilty verdicts in 7 of the 10 counts. After a day off, they returned for a 5th day, at the conclusion of which they convicted of the 3 remaining counts. The problem is that there were some issues that arose in between the 4th and the 5th day and into the 5th day that we contend compromised the jury and rendered the jury panel not impartial.
So the judge determined that the jurors had been exposed to some extraneous material, right? We agree with that?
That's right.
All right, and she conducted a fiddler hearing. Do you agree with that?
I agree with that.
And do you have any quarrel with the way she conducted that hearing?
Don't have a problem with that.
So is it your position that juror 7, who the judge found not credible, is beliefs or their affidavit trumped all of the other jurors' collective memories?
Well, I think there's, it was not just this juror who said, I was familiar with Facebook and I was involved in this. It was actually a number of jurors who were exposed to the Facebook stream. There were 2 jurors who were actually Facebook friends with Mr. Tornovich.
The judge, though, found at the end of this hearing, beyond a reasonable doubt, that these deliberations were not affected by this extraneous information, and discredited that portion of juror number 7's testimony, where she said she was affected. You're asking us to reverse that. So does that mean you're asking us to find that there was insufficient evidence to support a beyond a reasonable doubt finding Is that what you have to show us for, as a matter of law, for us to reverse that?
Well, I think on appeal, once we met our initial burden, the Commonwealth had a burden of proving beyond a reasonable doubt that there were either no extraneous matters or that the deliberations weren't compromised.
And the judge still found.
The judge did make that finding. We contend that, I don't think she completely discredited juror number 7.
She didn't, but she did discredit that portion where she said it affected her deliberations. The judge specifically concluded that, and look, I have no idea. I didn't hear the person testify. And of course, I really have no idea. It's inside her head and a long time ago. But the judge concluded that she had changed her mind about the guilty verdicts subsequent to the trial, and that that's what accounted for these statements. So what we're left with, assuming that's a valid thing for the judge to do, and you may quarrel with that, but if the judge can do that, what we're left with is several jurors, 2 jurors who saw a Facebook page about this and lied to the judge about it, and several jurors who understood there was a crowd of people outside the courthouse who were disappointed and angry about their acquittals on the previous day of deliberations. And I guess my question to you is, it's follow on from, you didn't really answer my last question. Is it your position that in the face of that, a judge can't say it's not reasonable to conclude beyond a reasonable doubt that no one was affected?
I think in the present circumstances, yes. The problem is that, before, we had this affidavit where the juror says, yes, our deliberations were compromised, and in particular, my deliberations were compromised. Now, at the hearing, the judge doesn't know how this is going to come out. The judge essentially told the jurors, don't tell us how you deliberated or how this affected the deliberations, because essentially the SJC says, you don't tell us what happened or how it was affected, but you tell us sort of what the influences were, and I will make the determination as to what, whether there was.
It's an objective standard, right?
It is an objective standard.
Okay.
So the SJC doesn't want to get into the deliberative process of the jurors. I mean, that seems like it would be a slippery slope for all cases.
Right.
But in any event, juror 7 says, certainly I was affected. But in the face of the whole process was affected, the court looked to the other jurors who didn't seem to think that. So what are we to do with that?
Well, I think what we do with that is that one juror being compromised is enough. And the SJC has held that.
But the judge didn't find her credible as to that score.
Well, I mean, I think you have to look at what she actually said. The judge did find that she was going on Facebook, that she was familiar, not only was familiar with Steve Tornovich and his post, but she was reading the responses.
Yeah.
What is the SJC case you rely on for one juror is enough?
Commonwealth versus Giusti, 434 Mass 245, and that's at page 251. And there's a more recent case from 2019, Commonwealth versus Cologne, 482 Mass 162 at page 167. And they
Website on Giusti is 245?
245, and there's a pinpoint site at page 251 where they say, one is enough. And, that was recently subsequent to the decision in the motion for new trial. Commonwealth versus Cologne, 482 Mass 162 at 167 said the same thing. If one juror has been compromised, and we do have one juror who says, I was compromised. I know the judge, didn't credit certain portions of her testimony, but
Well,
she
he didn't credit that portion of her testimony. So I'm trying to figure out, and you still haven't answered my question. Is he, A, Are you saying the judge may not discredit that? Or are you saying B, even with that discredited, this must be reversed? And you haven't told me the standard of review, but I'm going to assume it is because once you have this evidence, no reasonable judge could find beyond a reasonable doubt that they weren't affected, because jurors who know that there's a crowd outside angry at them for their acquittals, objectively, no one can say beyond a reasonable doubt that they aren't affected by that.
I think probably B. I mean, she testified that we had a discussion, the jurors had a discussion, and we were all compromised and we changed our verdicts. They don't have to, the judge doesn't necessarily have to credit that. But when the juror says that she was compromised, which I think she does say.
Yes, she does.
Yeah, she's not supposed to, but she does.
And so the judge has to deal with it, but the judge did by saying, right, I mean, you can imagine, I don't think it's this case. You can imagine someone lying about that. You can imagine someone having a gun pointed at them at their house and being told that if they don't go in and say that they voted this way, that violence is going to be done to them. And you can imagine them getting up and testifying like that. A
Certainly.
judge must be able to say, I don't find it credible, right?
I mean, I think I would agree, but I think you have to look at the context of this case. That's not what happened here. What happened here is that between the fourth and fifth day, trial counsel came forward and said, look, we had these Steve Tornovich posts, and we have people coming in with teal shirts and ribbons, and there's something's going on here. We want to make sure that, you know, nothing happened, and something did happen. And
Counsel, there was a motion for the judge to address that directly with the jurors, and it was denied after a hearing where the trial judge got on the phone. Do we have the transcript of why? Do we have any understanding of her rationale for denying the motion to address it directly that last day of deliberations?
I don't think we do, but I think, you know, having been denied, I think, you know, the judge did make the right call and say, you know, you've met your burden and you're entitled to a hearing. And and at that hearing, the burden then shifts to the Commonwealth. And that's what we did in the January, February 2019 hearing.
Can I ask you a question about your fair cross-section claim? Or I guess the fair cross-section claim that's buried in the, or not buried in the, but that's underlying part of the venue change motion. The unavailability of Hispanic jurors on Nantucket. The Commonwealth says that you did not put in adequate evidence of the veneer, the juror pool, and so on, for us to be able to tell. Do you think there is sufficient evidence, and what is there? I mean, they also put in something that shows a higher percentage of Latinx population in Nantucket than in the surrounding parts of Barnstable County. So
it's slightly higher. I mean, I think that's we put in what was available. That's, you know, and that's only part of the argument, by the way.
No, I understand, but you didn't put in anything about, and this veneer, even for Nantucket, is disproportionately non-Hispanic, or this Pettit jury is all white or has no history. That nothing about the race of actual jurors was put in. Is that right?
I think that's right.
Okay.
But I also think that the issue with the pretrial publicity, there was some pretty horrific stuff in there, you know, talking about, and there were also comments in the newspapers that we put in about.
Oh, I wanted to ask you this.
Of course.
No one tells us this. He was acquitted of a whole 7 crimes. What were the differences? What was he? I'm in trying to figure out whether it makes any sense, whether the jury was overwhelmed by this crowd outside. If there were no difference between the cases, maybe that would tell something. Oh, of course there must have been, because they weren't settled on them at the same time. What was he acquitted of and what was he convicted of?
Well, he was,
Charges, I mean, what are the underlying facts giving rise to each charge? If
well,
you know.
the evidence was that this incident started at a particular location, and then he drove her to another location and, you know, tried to finish and did the same thing. Now, the jury acquitted of the first 7, I presume was one set of facts, and then the second set of facts. I mean,
You presume that, but you don't know. You don't know for sure whether either the indictments or a closing argument or something, opening arguments specified what events were led to each count where there was an acquittal.
I'm sure there was something in there instructing them as to what counts there were and what counts went with what incidents. I don't see a compelling reason to say, well, this part of it happened at at the beach and on the road. This part of it happened in the, you know, arising or giving rise to a second set of similar charges.
Well, the jurors obviously saw a very compelling reason to draw a distinction because they were prepared to reach a conclusion unanimously that certain of them, they weren't proved, and others they were at least hung on before the final day of deliberation. So they obviously saw a difference, right, in the evidence?
You know, they may very well have seen a difference. They may have believed, who knows, maybe that it started out consensual and ended up non-consensual. There wasn't any testimony, but we don't know.
He did admit, I don't know if he admitted, I mean, I found the description of the facts quite baffling. I don't know if the hypothesis was that she was hit by his car or something, or why she woke up in a ditch is not explained, but he did admit to having sex with her at some point, and maybe those were, you know, those were the events but you don't know specifically. We can obviously look.
Right, and I'm not sure if you're going to get a great answer. I'm a little bit baffled by the you know, some of the underlying facts myself.
Your sister may have a pure sentiment.
The Commonwealth case was, I mean, fairly strong. He says it was consensual. Certainly he was in the area. He had been stopped by a police officer driving around at 3 a.m. out there. He admits that he was with her, and she's beaten and goes to a Good Samaritan's house in the middle of the morning for assistance, and has suffered some fairly visible injuries. So it's kind of, who do you believe? Do you agree that it came down to that?
I think that may have been it. You know, but it's really, you know, she was kind of probably almost blackout drunk. So I think, you know, she couldn't really give an clear account of what happened.
Swollen shut too. All right, your time has expired.
Can I just explore something? I apologize, but
Sure.
I'm back to the question that Judge Rubin asked you at the top. And he says, the judge has found that the Commonwealth carried its burden beyond a reasonable doubt. And that seems to me to be a finding based on facts presented to the judge. And so my question for you is, what's our standard of review?
It's not clear. It may be a de novo review of the underlying.
We didn't hear the witnesses. How can we do de novo review of how much weight to give each witness's?
Maybe not. I mean, I think my contention is that there is enough there supporting that there were clearly extraneous influences that affected more than one juror, and there were discussions of that in the jury room. And as a result of that, there were 2 different sets of verdicts. And I don't think and you have juror number 7 who says, yeah, I was affected. It affected me. So even if it didn't affect any of the others, it affected her. And this isn't a case where she was coerced or threatened.
All right, your time has expired. Thank you very much.
Thank
Very
you.
good argument. We will turn to you, Attorney Sweeney, and perhaps you could very briefly, if you know, what is there something distinguishing the 7 counts on which this defendant was acquitted from the final counts on which he was convicted?
So the verdict slips were not written with any specific delineation of a location. I would turn this court's attention to the prosecutor's closing argument and just the Commonwealth's summary of how the facts occurred, where it was a rape that occurred at one location, and then the victim was out of the car and led into the car again, and the 2 rapes occurred again.
We'll have to look at the closing to see what each count is supposed to be.
Sorry, I couldn't hear you.
We'll have to look at the closings to see what each count is, or the instructions to see what each
Yes,
count.
it was addressed by the prosecutor and the
So
judge.
can I ask you, I'm going to ask you just the reverse of the question that I asked Attorney Carhan, which is this. A jury is deliberating. We can say it's in a small town. I'm not even sure that matters, but okay, they're deliberating. They issue a bunch of acquittals, and then they, in the jury room, at least several of the jurors hear there's a crowd of people outside who are disappointed and angry about our acquittals. And we still have 3 counts left in the same case. Can anyone say beyond a reasonable doubt that they weren't affected by that? That's a pretty bad, I mean, you don't want jurors to know about that, right? I mean, that's...
Obviously, oh, sorry, I didn't mean to interrupt you.
No, please.
Obviously, the Commonwealth has an interest in trying a fair case. However, I would not classify what occurred with the community members to support the victim as angry and disappointed. The judge found that there were...
The testimony of some of the jurors was they heard that they were angry about the acquittals. I read that's angry or disappointed or both. I don't remember.
One juror testified that their town was disappointed about the acquittals, and then there was a reprimand by the jurors. We're not supposed to discuss that. And then they turned their deliberations. Well, it wasn't even during deliberations. It was prior to the jury even getting instructed.
Okay, I agree with everything you said. But so some of them heard that there were people outside disappointed in what they'd done the day before. How can someone say beyond a reasonable doubt that that doesn't affect the jurors and that there shouldn't be a mistrial or a new trial in this case?
Because there was a full evidentiary hearing before the motion judge, who also served as the trial judge. The jury was instructed every day of deliberations with the written instructions by Judge Topman, and she also read the instructions to the jury.
But they lied. They lied. 2 of them lied about it. They said they hadn't heard anything outside, and they'd read Facebook posts.
Yes,
so
they did not inform the judge that they saw Facebook posts. However, nobody during the testimony recalled what the content of the post was. The exposure was brief. The jury turned their conversation back to other discussions, including weather, and they reprimanded themselves and redirected to what they were supposed to discuss. And the standard is that whether the extraneous matter produced such a high probability of prejudice that error must be inferred. And the facts of 10 people standing outside, not interacting with the jurors, not having a conversation with the jurors, no signs, there were no words or names that were called at the jurors, whether people supporting the victim creates such a high probability of prejudice that it must be inferred. We don't have the facts here after the evidence.
This is a little different. Lots of times, particularly in a high profile case like this appears to have been in Nantucket, the courtroom every day has people there supporting the victim. That's very normal. And there's nothing, it's public courtroom, it's permissible, there's nothing to be done about it. I mean, if it's intimidating, that's one thing, but assuming everyone stays quiet and just sits there and isn't doing anything threatening or whatever, that's luck of the draw. That's a little different from hearing they're disappointed in our verdict yesterday. That's not just there are people who support the victim. That's our neighbors are mad at us and we have to go back out and live here.
But there's no evidence from the jurors that there was a lengthy discussion on that comment, and other jurors testified that the comment was due to the packed room. The packed courtroom was filled that day just because of the nature of, it was a Nantucket jury
You got
assignment.
two jurors. I mean, I just reread her findings. You got two jurors, in addition to the two who saw the Facebook posts, who say they understood that they were, quote, angry or up in arms or disappointed.
Yes.
I mean, it seems to me, building a little bit on what Judge Rubin just said, I'm not always certain in cases like this what we're really concerned about, what is a legitimate concern and what is not. Because one concern we have is you're going to put in evidence that wasn't before the jury. That's sort of the classic extraneous matter, right? But this is sort of community pressure. I mean, most of what we're talking about is not specific facts, but community pressure. And it seems to me that, as Judge Rubin points out, people can just show up in the courtroom. Jurors are going to be aware from the nature of the case that the community is going to care what the result is, and that the community is going to want the person who did it to be convicted. Are there any cases that help us sort out
There's no specific
legitimate
case.
concern from what is not with respect to extraneous matters?
There's no specific cases that deal with the people supporting the community or supporting the victim. In my brief, I focused on the high standard of abuse of discretion after an evidentiary hearing where the judge found that the Commonwealth proved beyond a reasonable doubt, and the judge found that Juror 7 was not credible. And the comments that you mentioned about anger and the community pressure, other jurors testified that the comment was just in regards to the packed room, and they described it as not a discussion, very brief. Several jurors said it was just a mention.
Yes, that's some of them. That's some of them. But some of them, I'm not sure it matters how many, but it sounds like at least 3 or 4 understood that this was disappointment and or anger, up in arms, if you like, not just about the crime and wanting to make sure that the person who did it is convicted, but that they want this defendant convicted, that they have apparently reached a conclusion different than the jurors have. Their conclusion is these acquittals were wrongful. I mean, who could object to appropriate acquittals, right? So they must have thought these are wrongful acquittals. And now the jurors hear about that. Our neighbors think we got it wrong yesterday. They think this guy is guilty.
There's no evidence that that was the discussion that the jurors had.
No
Again,
discussion. You keep focusing on discussion. I'm focusing on what's in the head of a juror. People are not idiots, right? Right? If you hear your neighbors are up in arms about something you did, obviously they think what you did was wrong. And now you have a chance to in this weird circumstance of, I don't know why people are taking half the verdicts. Maybe they think it's going to lead to a plea or something. I don't know. But they take half the verdicts or 7/10 of the verdicts. And then there's this further piece of information from the community.
well, it's the effect of this information on the average hypothetical juror. And we have the benefit of a full evidentiary hearing. And again, there were 10 community members outside. Several jurors walked in a separate door so they would not walk past them. And the mention of it was very brief. And the jury had been deliberating.
Walking in a separate door, I'm sorry, counsel, walking in a separate door cuts against you, not in favor of you. It suggests that they knew before they even got to the courthouse that there were people upset and that they didn't want to interact with them. And that goes along with, look, one of the biggest problems which has been unspoken so far is the purpose of the Facebook post was to put pressure on the jurors. That was its purpose. That's what he asked. Go and show your support for the victim.
I respectfully disagree. First, for the going in a separate door, the foreperson who's deceased, we do not have her testimony, called another juror and said, there's people outside, just go in a separate door. I don't see how that cuts against me in the sense of the other juror doesn't know why those people are there, just entered a different door in the Nantucket District Court Superior Courtroom.
I
And
thought that the testimony was that she got a call that there were protesters outside.
I don't know if it was the word protesters, but she got a phone call that there were people outside.
Demonstrating in front of the courthouse.
Yes.
Do you think that it's not a reasonable inference from that description that they understood the demonstration had to do with the verdict that they rendered the day before?
I don't think that we can't get into what the juror's mind was, but she obviously excused herself and they avoided exposing themselves to any influence. That's what the judge explained for them to do. Avoid media, avoid exposing yourself to this. So they went in a separate door. It shows that the jury is following the judge's instructions that she instructed every day, and Judge Barrett on that same day. So then when the judge said, did you have any exposure to any media? She was able to address, no, we didn't see anything. So the jurors practicing what they're supposed to be doing. And again, it's such a high standard of abuse of discretion. Did the judge abuse her discretion in denying the defendant's motion for new trial? On this set of facts and the testimony from the jurors, the defendant has not met his burden to show abuse of discretion. Juror 7 was found to not be credible. The juror 7 testified on page 34 of the motion first day transcript that the context of it was there were people in the courtroom, Facebook posts, and a person interrupted the conversation and said that we can't discuss that, and that shifted the conversation. That's the juror 7 that she found to be not credible, that she was intimidated by the Facebook posts and by the...
And that's, I think this is certainly consistent with our case law. You say that the standard of review is abuse of discretion.
Yes. Commonwealth v. Grace, and I'd cite to Commonwealth v. Bernier and Commonwealth v. Walker to support that. And so did the judge...
That address a situation where there's been an evidentiary hearing on whether there was extraneous impact on the jury?
No, that's just the standard of Commonwealth v. Grace of a normal evidentiary hearing motion for new trial.
Right. Do we have any cases that address the standard of review in this context?
I was unable to find any. I would just cite to Commonwealth v. Kincaid and Commonwealth v. Fiddler, where they remanded it for an evidentiary hearing. With
right. Those cases are a different, it seems to me, very different question, right? Those are like, have you met the threshold in order to even question the jury? In fact, the case that your brother cited to me was also one of those cases. But here we have full evidentiary hearing and a finding.
Well, Commonwealth v. Fiddler discusses the matrix of factors that the court is supposed to apply in determining whether or not there was an extraneous influence, including whether the comment had an immediate rebuke from another juror. We do have that in this case. Whether there was overwhelming evidence of guilt. There was overwhelming evidence of guilt for the verdicts of guilty that we had in this case. And also whether the extraneous matter produced such a high probability of prejudice that error must be inferred. And on this set of facts, the defendant cannot meet his burden, where only 2 people saw the Facebook post. They did not discuss the substance of the Facebook post. It was prior to the deliberations that day. And it was, again, a mention, not a discussion. They talked about other things. And in their own words, it was very brief. So I suggest those comments, in their own words, in the jury's own words, the defendant cannot meet his burden to show that the judge abused her discretion after the evidentiary hearing. If there are no further questions, I rest on my brief. I can't.
I mean, I would just say, it seems to me that there seems to be case law that supports trying the defendant in the location, in the area where the offense took place. And that's because the community has a vested interest in the matter, right?
Yes.
Okay, so we expect the community to be aware or to be involved, maybe not per se involved, but to have an interest in the outcome of the case. And to have jurors who come out to support a victim is not uncommon. So on these facts, I mean, it seems like the complaint is how the judge came out, but it seems there was certainly support in the answers that were provided from the jurors for the judge to reach her conclusion. So is it an abuse of discretion that we're looking at with respect to the judge?
Well, the Commonwealth asserts that the judge did not abuse her discretion in coming to this conclusion after the testimony. And I see my time has expired. I'll answer your question. In her decision, because she reviewed the testimony of all the jurors, and she noted that Juror 7's testimony was not supported by any other juror. There was no evidence from any single juror that they were intimidated, that they were influenced, or that they, and nobody reached out other than Juror 7 saying that there was an issue with the Facebook post, or that they were upset or concerned, or didn't bring it to the judge's attention and they were upset with it like Juror 7 did. No, the judge found there was no evidence or credible evidence supporting Juror 7's statements. And she found that it appeared as though Juror 7 had a change of heart, which is not a reason to allow an individual to have a new trial. Because
your time has expired, Attorney Sweeney. Unless there are further questions.
Best guess, what time do you think we'll get started?
15 seconds from now.
Oh, okay.
It's just a free flag for live.
I see. Okay.
And we are live.
Welcome to the Appeals Court. Good morning. Our next case is number 19-1566, GERFMAN Global LLC versus the Nautica Leasehold Condominium Trust. I am Justice Rubin. I'm joined by Justices Desmond and Englander, as you can see. We are hearing argument by video conference rather than in person due to the ongoing pandemic. The rules of argument are the same as they are in our courtroom, which is to say 15 minutes per side and no rebuttal. We have read your briefs with care and are familiar with the facts. You may want to get right into your arguments, but it is your time to use as you wish. And we have an appeal and a cross appeal, but I gather we are going to hear first from Mr. Moriarty.
Thank you, Your Honor. Good morning, Your Honors. Thomas Moriarty for the trustees of the Nautica Leasehold Condominium Trust. I will be addressing 2 points in this morning's argument. First, the trial court's decision should be reversed as regards the method of assessing common area expenses to the condominium common area and residential common areas. And the trial court's decision should be affirmed as regards the denial of the plaintiff's request for reimbursement of common area charges assessed prior to May 5th, 2016.
Can I argue that that's the second half of that, the reimbursement or non-reimbursement? The judge didn't really explain why he treated those, whatever it was, the 2013 to 2016 payments as not having been timely paid, although maybe it's a fact that we deferred to, I'm just not sure. And I gather, I don't really understand what's happened. Maybe there's nothing in the record. Statements were being sent routinely to GERFMAN through April, maybe of 2013. I assume, although I don't know that this is in the record, that the residential unit owners receive statements or assessments, or I don't know what you want to call them, bills every month. Or maybe it's automatic or something, or they're told at the beginning of the year. I have no idea. Of course, GERFMAN is in the unusual situation of having its own person on the board of trustees. So obviously it has at least constructive notice, maybe actual notice of the budget. And I assume that you can break down, or that there is a breakdown of the, of what the assessments are for each unit owner, including them under the trustees calculation, but we don't know any of that, do we?
Your Honor, we don't know all of that, but we do know some of that. It is correct that there were assessments done monthly from January 2013 through April 2013, and that GERFMAN does have a representative on the board. We also know that as of October of 2013, GERFMAN filed a lawsuit challenging the assessment. So,
And so by doing that, and had he paid him up until then?
no, Your Honor, no assessments were paid from January 13th forward.
Till 2016.
That's correct, Your Honor.
Did the January through, sorry,
And
go
then
ahead.
did he pay a lump sum?
Yes, Your Honor. On May 5th of 2016, or I should say shortly before that, GERFMAN requested a summary of then outstanding charges. The association provided that summary of charges, and the day after, GERFMAN paid the amount that was summarized by the board. GERFMAN's,
go ahead, I'm sorry.
I'm sorry, GERFMAN's argument is that that notice of the accrued common area expenses from 2013 through that date was essentially the assessment. But what we know too from the decision, to go back to Justice Rubin's question, what we know too from the decision is that the trial court specifically found that assessments were made in 2013, 2014, 15, and 16.
Well, he found that, but he doesn't tell us, to go back to Judge Rubin's question, how they were assessed. But this is very helpful. The statements in January, February, March, and April of 2013, were those done under the new accounting method that included these other charges?
Yes, Your Honor. It would be, yes.
GERFMAN had notice by those statements of the new accounting, and then he brought a lawsuit in October challenging it. Is that right?
Yes, Your Honor.
And that's all in the record?
Yes, Your Honor.
And that was because the number changed dramatically from what he was used to.
Oh, the number certainly changed in January 2013, Your Honor. The method and mechanism by which assessments were.
We have nothing except an inference. Is that right? As to the failure to pay. That is, of course, if GERFMAN had said, and there's certainly no evidence of this, stop sending me these annoying bills, then we might say, well, all right, whatever, you had constructive notice or something. Is that what we have to find here? That the failure to pay for 4 months in a row while you're having an open dispute, and then months later, but still in the same year, you file a lawsuit, that we just excuse the failure to bill? Or is failure to bill not the issue?
So from the trust perspective, Your Honor, failure to issue statements is simply another argument that GERFMAN would have to challenge the legality of the assessment. So GERFMAN has two arguments. One is the assessment is not consistent with 7B 1 and 2. The second argument is, you didn't issue statements. There's a procedural infirmity. The trust position on that is, if in fact GERFMAN could assert to this court, or did assert before the trial court, that he did not, or it did not have actual notice of the assessments, it could be a different scenario. Those are not the facts we're presented with. We're presented with evidence that GERFMAN was aware of the assessment, had in fact filed suit, and that suit remains pending.
Yeah, but let me ask you this. How was GERFMAN aware of the July 2014 assessment?
So that would have been just as a function of the availability of the budget, Your Honor.
And
I'm not sure I understand the answer.
So just the budget reflects an assessment that's made at the beginning of the fiscal year. So was there a statement that was provided during that period of time? No.
But I need to understand this a little more. Statements were presumably provided to every other unit owner.
Your Honor, I can't say with certainty that that is reflected in the record, but we don't question that. We would recognize.
You're not saying there's a sheet that breaks the budget down into assessed percentage amounts. That is, you're relying on GERFMAN doing some math to figure out what its share of the CCE assessment was. The budget breaks it down in that way?
Well, Your Honor, the budget will show what is broken down. So you can look at the assessment and look at what was assessed to the parking garage units. But that's not exclusively what the trust is saying or what the trust is suggesting this court should look at.
But before we move from that point, the budget is expected or anticipated assessments, right?
Well, assessments are in fact based on the budget, Your Honor. Costs are not necessarily consistent with the budget, but the statute requires, and what the board did was generate assessments based on the budget.
So
assessments are tied to the budget.
Is the assessment made for each unit at the beginning of the fiscal year, which I take it is the calendar year?
Yes, Your Honor.
And then you're simply sent 12 bills. They divide it by 12 and send you 12 bills. But you know, you're notified somehow on January 1, this year's assessment is going to be $18,000 or whatever it is for each unit. Or we just don't know, or this is completely, we have no idea.
Well, Your Honor, I would represent that the court can take judicial notice of the fact that math can be applied. But yes, in the record are budgets, and there's no dispute that budgets were adopted. There was no.
That was my question. I'm asking what day. I'm a residential unit owner. What day am I assessed for July? Am I assessed the whole year on January 1 and then I just get a bill? Is it a bill that arrives, but the assessment took place on January 1? Does the assessment take place on the first of each month or 2 weeks before that when a bill is sent? I don't understand how it works.
So the assessment is made at the beginning of the year. The statement is sent each month and it becomes due and payable within 30 days after the statement.
And is that by practice? Is it in the bylaws? How would I?
That's in section 5.4B of the Declaration of Trust.
All right, so.
And so if somebody got the budget in the beginning of the year, they could pay it right then. They wouldn't have to wait for the 12 states.
They could pay it in advance, Your Honor. Now, it's always possible that the budget could be amended, but yes, they could theoretically pay it in advance.
So for 2013, there was a budget and there were actual statements sent to GERFMAN for 4 months.
Correct, Your Honor.
Okay, and GERFMAN didn't pay.
Correct, Your Honor.
And was there correspondence from GERFMAN where he said, hey, you've changed the way you're assessing me and I think it's wrong, before he filed suit?
I'm sorry, I do not have the understanding as to whether there are communications in the record that specifically say that. I know that there were communications by which GERFMAN asserted an objection to the mechanism.
Was that by Hoffman?
Yes, Your Honor.
So now let's move forward. In 2014, no statements are sent, but you say there's a budget prepared and that budget is available to whom? Is it available to the board, including Hoffman?
It's available to all unit owners, Your Honor. The General Law, Chapter 183A, Section 10 makes the books and records available to all unit owners, and that includes.
But it's also voted on by the board, right?
Yes.
That including GERFMAN's representative on the board.
Yes, but I won't represent that GERFMAN voted in favor, but I will represent that GERFMAN was participating through Hoffman on the board.
He was present when it was, he may have voted against or for, but he saw it.
He saw it and would have had the opportunity to vote on it, Your Honor. And what's more, Your Honor, there is an additional point I did want to get back to. Really, this goes to the original question posed by Justice Rubin. And that is, a unit owner understands when they acquire their unit, as did GERFMAN, that they would have to pay something. They disputed the mechanism that was employed by the board commencing in January 2013. But they could have also simply requested the information. The argument that GERFMAN is making is that they were aware of those 4 months. They filed suit in October of 2013. Now, obviously, to say that the assessments were made in May of 2016 and they filed suit in October of 2013
Counsel, I think we got this, and there are only a few minutes left, and we have other issues. As to your CCE, RCE question, you have raised the question in your reply brief as to whether the entire scheme is inconsistent with 183A Section 7. Was that issue raised with the judge before?
No, Your Honor. That argument is raised only to address GERFMAN's argument in its principal brief that the mechanism adopted, or the paradigm adopted in the master deed and the declaration of trust, are permissible as limited common area charges. So the defendant was addressing just that argument.
So the issue before us has nothing to do with whether, as a matter of statute, the assessment could not be done that way. The issue
Correct, Your Honor.
before us has to do with the construction of the trust instrument.
That is correct, Your Honor. The trust point with regard to that issue is only that GERFMAN's argument that it is defensible as limited common area charges is not correct. And that is relevant to the court's assessment of what the board says are two provisions that are, if interpreted by the strict language of the document, leave out a classification of charge. That is a charge that is applicable to both CCE and RCE.
Can you give an example?
Yes, Your Honor. Actually, I can take it right from the court's decision. The court's decision in adopting testimony by Robert McBride recognized, with regard to the alarm expenses, that a budget could be created showing the RCE areas and indivisible alarm expenses, not RCE and CCE, but RCE and indivisible alarm expenses. And
But why can't those be attributed? I mean, you're going to divide them further among all the different units, right? Why can't you attribute some percentage of the alarm expense to CCE and some to RCE, and then use the proper percentages?
Because, well, we think you can, Your Honor, but if you look at the court's decision from pages 13 to 15, a fair reading of the court's analysis with regard to that allocation deprives the association of the ability to apply any shared costs to CCE. That is, the court has concluded.
That's not what Justice Rubin just said. Justice Rubin said, if you assume that you're correct, this is why I understand his question. You assume that you're correct, that there are some that apply to each in the sense that they're indivisible. Why can't you just allocate them out? Why can't you say, of the alarm expenses that apply to both, 43% are CCE, 57% are RCE, and then move forward?
Perhaps I was inarticulate, Your Honor. I apologize. I was trying to answer that question. We think it can be done, Your Honor, but the court's decision on pages 13 through 15 essentially says that any element that is attributable exclusively to CCE can be charged to CCE. In fact, Your Honor, what the court challenged was the trust's policy and practice of saying, well, if something is applicable to both, it can be applied to both and then divided such that the residential unit owners pay 82%.
Yeah, so that's not applying it to both, that's applying it to CCE. But we will ask your brother, because I think you're overreading the decision and the way he reads it. I think he says you can allocate. If he doesn't, then we'll have to figure it out. But your time has expired. Are there further questions, though? I don't want to cut off. Okay, thank you very much. Very interesting, really interesting case. Excellent argument. We will hear from you, Attorney Cowan.
You're on mute. You're on mute, sir.
Oh, so that's not going to work. Hold on.
Is that better?
There you go.
Yes, all right.
Okay. Thank you for bearing with me. Good morning, Your Honors. May it please the court. My name is John Cowan. I represent the plaintiff and appellee, GERFMAN Global LLC. I want to remind the court that the impetus for this lawsuit was an issue that was decided by Judge Kaplan What happened prior to January of or right in January of 2013 was that the trustees made a retroactive assessment covering a 5-year period and demanded that GERFMAN pay that retroactive assessment of $617,000. That was really the start of this dispute.
Okay, that doesn't really matter to us though, right? Because that's not
Well,
before us, and we're not going to hold them liable for everything you allege just because they did one other thing wrong. So let's go, if we could cut to the chase of the question that your brother was answering at the beginning. If there is an indivisible expense, an alarm system, is it your position that the full amount of it goes in RCE, or can it be allocated, some to CCE, some to RCE?
to the extent an expense can be allocated, I think what the judge found, and it was based on expert testimony, was that it should be. If it can be, it should be.
So
If
if
it cannot-
indeed an alarm system is put into the entire building, including the parking garage, and the trustees conclude reasonably that 13% of the value of that goes to you, because the parking garage has a size of 13%, or however they would allocate it, some way, and 87% really benefits the residential buildings. You believe that the judge's decision allows the trustees to allocate that 13% to CCE, and of that you'd pay 17%, and allocate, or I think that's the number, and allocate the other 87% to RCE, of which you'd pay none. But you
That's right.
would pay something. All right, that's what I thought your position would be.
Yes,
You-
yes,
go
Your
ahead.
Honor.
But
And
when
in
you,
doing so, they have to show that those percentages are in the CCE column and in the RCE column separately.
Yeah, again, if, for example, just to make this concrete, there are elements of the alarm system that service solely the residential buildings, then that is a charge that should be clearly classified as an RCE expense. If there are other expenses related to the alarm system, annual testing, or controls that apply to the entirety of the condominium, then those charges are properly categorized as CCE expenses.
properly characterized as CCE, not allocated between RCE and CCE in the first instance?
If there are charges that can be reasonably allocated, again, the expert testimony and the judge's finding is that they should be. But to the extent that there are charges that relate solely to RCE, there's no question those should go into the RCE.
Give me an example. Give me an example of an unallocatable expense that winds up in CCE.
Well, I think it would, one example would be administration performed by the property manager, Hodan Management. So she does, and Vera Barter testified at trial, she provides certain services that relate to the entirety of the trust. She helps set up the trustee meetings. She helps respond to concerns of all of the unit owners, even though GERFMAN has on very, very few occasions had a need to request assistance from Hodan. That's an expense that we would concede go properly into the CCE budget.
That goes into CCE in the first instance.
But I thought you objected to the office expenses being put in CCE. I thought you said that's not where they belong.
What we objected to was those expenses, for example, that such as the superintendent. The superintendent is on site responding to calls from the residential unit owners. My window can't shut. Come fix it. So that is an example of an expense that can and should be allocated. It's very possible.
Slow down. But you also call that superintendent maybe too. Hey, there seems to be a little water here in the garage. Could you come down and check it out? Is that right? And
I'm sorry.
Yes. And for some reason, that has to be paid for 82% by the residential unit owners. But when he goes up to the residential unit, it has to be paid 100% by the residential unit owners. That's your position?
Well, let me try to clarify this. So the testimony at trial, and as the trial judge found, there are certain expenses that can be allocated. And the example I was giving for the superintendent was that the superintendent can track those expenses, which are very infrequent, on which he is servicing an element of CCE. And by the way, it's not just the garage that has a right or an interest in CCE, it's the entirety of the condominium. So on those few occasions when the superintendent is doing something related to the CCE, in other words, not an issue related to the residential buildings, he can keep track of his time, and that time then gets
What about his
allocated.
general salary that when he's not spending time on either, but they hired a superintendent, right? And he's there, he's waiting to be called. Do you agree that those expenses either need to somehow be allocated between the two or put in CCE?
I would concede that on those occasions where the superintendent is not doing either, attending to RCE or CCE, there's some component of it that would probably properly fall within CCE.
Wait, some component. A minute ago, you told us that the trustee office manager, the management company, is all in CCE. That was your position. Why would the superintendent sitting there doing nothing also be, why wouldn't it also be in CCE?
I think the answer, Your Honor, is that the superintendent is in the field responding to resident issues 99% of the time. He is on site at the Nautica responding to those issues. He's not sitting in his office. So to the extent there are certain occasions wherein, and I can't think of an example, over the 7 years this case has been pending, where there's a call from the garage, there's a puddle in the garage, can you come take a look at it? The testimony and the conclusion of the trial judge was that cost can be allocated to CCE.
Okay, so now I'm the office manager and I'm sitting there and I get a call from a residential unit owner. And she says, I'm thinking of, I don't know what the manager does. I'm thinking of having a couch moved in. I need to get the freight elevator opened. And so the manager says, okay, great. I'll call whoever opens that, or I'll do it myself, whatever. She doesn't have to write down, work for a unit owner, a residential unit owner for 18 minutes on getting her couch into her unit. That's okay with you. But the whatever the other person is, the superintendent, that you don't like. I absolutely am baffled by that distinction.
Well, the answer, Your Honor, maybe you're not being articulate, but the answer is the property manager, Hodan Property Management, provides services related to the entire management of the condominium.
Not right while not right while she's opening the freight elevator in building 4 for a unit owner to put their couch up.
No, that's not something that the property manager would do. That would be the superintendent.
You think they call the superintendent directly, they don't call the property manager?
Well, if they call the property manager would put the superintendent in touch.
Okay, so the 2 minutes of that call goes in RCE.
I mean, obviously, to a certain extent, you cannot parse seconds and minutes.
Well, the lawyers do. We get attorney fees requests. I've seen seconds and minutes parsed.
All right.
I don't know how accurately, but I've seen them parsed.
Now, I guess the point, Your Honor, is that there comes a point at which it no longer makes sense to try to track those seconds and minutes.
But correctly, you would.
Well, conceivably, to the extent that's reasonable and possible to do so, then yes, that time should be tracked.
Part of your concern, as I understand it, is that there wasn't even an effort in growth, if you will, on the part of the trustees to do this. There was no differentiation between RCE and CCE. Is that right?
That's correct. And the position that had been taken that the judge addressed is that the trustees believe that to the extent there was any possible component of effort related to something other than the residential units, that expense could be put entirely in the CCE budget.
Now, let's say we assume what seems to be the case, which is that this original arrangement is self-dealing by the developer. The developer decides, I'm developing this property, I'm going to operate the garage. Here's an idea. I'll create a category I don't have to pay for of a bunch of stuff of which I get the benefit. There's a fence around the thing. I need the fence just as much as the residential people do, but I'm going to put that in RCE. And no one could park there at all if we didn't pave the whole thing, but I'm going to only put some tiny bit in CCE, and I'm going to try to shunt all these expenses over. I'm going to say that it's because of who has an undivided interest in what, but at the end of the day, I'm allowed, because I'm the owner of the garages, I can walk through the lobby of the building, I can park on the circle out in front, but I'm going to put all that in RCE so I don't have to pay for it. Is there any remedy for the owners who later discover, I know it was in it and they had notice, can they go into court and get a declaratory judgment action for seek a declaratory judgment that things were improperly put in one category of limited costs rather than the other?
Well, we don't really have a record to go on here. None of that was part of the testimony that was provided at trial. We never heard from the declarant, the developer of the property, as to what his intentions were.
Well, he's not really know.
The question could be answered based on the trust document itself.
Right, the master deed.
Yeah.
Let's assume that the trust document itself is enough potentially to allow someone to make the argument that Judge Rubin just made. Is there a remedy?
Well, there might be. I don't see it in this case, Your Honor. The trust documents clearly call out, and with reference to physical plans, they identify quite explicitly which areas of the condominium belong to which category.
Yes, but presume, let's say they had created category D, which is the penthouse. And that's actually where the developer will live until he sells it. And category D only has to pay for lighting in the lobby. Every other shared expense is all the other unit owners. But he only has a limited common area. He has no legal interest. He has easements, though, instead. Easements over everything, no legal interest. Can they do that? Is that lawful?
This is a hypothetical question, Your Honor. I guess it would depend on whether that creation, whether that document complies with the requirements of the enabling statute.
Of 183A section 7, the one that got cited perhaps belatedly in this case. I mean, the difficulty, I think, this is just me speaking, is there's category 1, which is RCE only. There's category 2, which is CCE, but only 17% of that goes to the parking garage. But there's no category 3, which is CCE only. So any expense that is just being used for the parking garage goes 82% to the residential. That's the imbalance in the way this was set up. And I don't know whether that's lawful or not, but I think that's what Judge Rubin's question is.
Yeah, so Your Honors, I think the confusion might be that there's more than the garage to CCE. So the CCE is defined in the documents as including 5 different categories. That's set forth, I believe, in the first phasing amendment.
The garage, the stairway to the garage, the railing in the garage.
and the rights to the leasehold interest in the property on which the condominium is sited. So, and the document very clearly spells out all of the areas that relate to RCE. So, all right.
Your time
I don't see that as an issue.
It's, I think it may not be raised here. It's, to me, that's the most interesting part of the case, is this odd division, but it may not be before us. We'll have to figure that out because your time has expired. Excellent argument.
And we are live.
Good morning. Welcome to the Appeals Court. I am Judge Rubin. I'm joined today by Justices Desmond and Englander. We are sitting by video conference rather than in person due to the ongoing pandemic. The next case we will hear is 19-591 in the matter of Albert Pecce. The rules here are the same as in our courtroom, 15 minutes per side, no rebuttal. We have read the briefs with some care, and we look forward to your arguments. We will hear first from Mr. Knudsen.
May it please the court, James Knudsen on behalf of Gino DiGiacomo. The judge, the probate court judge, clearly erred in this case by deciding that the petition for reformation should be dismissed, but then going on and reforming the trust and saying that it should not be, she declared it is not a D4A trust, even though the trust states, and I've cited extensively, just have to read the trust, it's clearly very emphatic about it being a D4A trust. And then she goes on to say that that what Mr. Pecce, the trust maker, testator, as well, and the decedent in this case, that what he really intended was a trust under C2B4 of the applicable statute. That's an issue. She did not even acknowledge that she was reforming the trust. In fact, she said reformation is inappropriate. She therefore did not hold herself, or Mass Health for that matter, to the clear and convincing evidence standard. By the way, Mass Health has not claimed, again, they have not acknowledged that what they're really asking is a reformation of the trust.
Well, they're saying it's not a reformation. They're saying she doesn't go that far.
Right, but both Mass Health and the probate court judge say this is not a properly settled D4A trust, even though the trust says.
All right, I'm confused about
this. Is a D4A trust.
I need to stop you right there because okay, so the language of boy, there's just too many numbers and letters here, but the D4A trust language. A trust containing the assets of an individual under age 65 who is disabled and which is established for the benefit of such individual by a parent or other people or a court if the state will receive all amounts remaining. Now you say this is not that trust because the money came from the parent rather than from Valerie, right?
Correct. But I would like to.
What tells us that? Because I look at this, and if you're right that it must come from Valerie, there is no reason for the language that it has to be established by a parent, grandparent, legal guardian, or individual. You could skip that. And it seems to me what happened here is the parent took the money and gave it to her so that she would have those assets. And so I go back to my question. What tells us that it can't come from the parent?
Well, the language of it itself, which says a trust containing the assets of an individual.
Sure, they're now Valerie's. I just took my $200,000, I gave it to Valerie. I'm putting it in that trust for her. Now they're hers.
That's not a gift. That's not a gift to her. That's to the trust, right?
Right, and Your Honor, and this is actually, if there's, I have probably 5 key points that I really would like to emphasize is that, and they're all cited in the brief, but under D2A, or really under D2, and I'm going to try not to read all of it just because, as you acknowledge, it's very technical. But for the key is, for the purposes of this subsection, an individual shall be considered to have established a trust if the assets of the individual were used to form all or part of the corpus of the trust, and if any of the following individuals establish such trust other than by will. And it goes through the individual spouse, etc.
A disabled person, I mean, I guess it doesn't say mentally disabled, So I suppose a disabled person could herself create one of these trusts, or no?
So, Your Honor, so the interesting thing about your comment is that in 2016, the law was, the D4A was changed. So that really doesn't apply now. So right now, an individual can create it for themselves, but at this time, it could only be created by parent, grandparent, guardian, or court.
And there are statutory specifications about what to do with funds from a third party that are put in the trust, which make clear that it can be funded with someone else's assets as well as the individual's assets. And therefore, it's not that when a third party puts them in, that is what is being defined as the individual's assets. Isn't that correct?
I'm not sure I understood your question.
All right, so I'm gonna say it again. A D4A trust can have assets in it that are the individual's assets. It has to. But it can also have a third party's assets in it. And those are treated differently by the law than the individual's own assets. And that's one way we know that when it refers to the individual's assets, it doesn't mean which belong to her after being put in the trust. It means ex ante, whose assets are going in. If they're hers, then MassHealth gets them at the end. If there are third parties, then MassHealth does not get them at the end.
Exactly, Your Honor. And
so let me ask you, so if that were the case, would that disqualify Pecce from getting Medicaid for himself?
so, I mean, the hypothetical question isn't real, I guess is hard to answer because he never applied for MassHealth.
It's not hard to answer. That's what a hypothetical is.
Right. So yes, if he had contributed assets to this D4A trust, then he would not have been able to apply for or be eligible for MassHealth, correct?
He also wouldn't be eligible for MassHealth because he retained about $700,000 of assets, right?
Correct, Your Honor. And in addition to this, Your Honor, and this is incredibly important, is that there's a lot of discussion actually in the findings of fact that Attorney Delaney, when she was appointed guardian in 2007, she went through an entire process to create exactly the kind of trust that MassHealth and the probate court judge are claiming this trust is, because she did not believe at the time that it was that type of trust. So it's a special kind of trust created under C2B4, and there's a MassHealth regulation as well.
I don't understand why what some attorney did 6 years later, who was not involved in the 2001 trust, dictates to us how we understand or read the 2001 trust.
I agree with that, Your Honor, except to the extent that it's relevant because the probate court judge relied heavily on Attorney Delaney's statements. They are throughout her findings of fact.
Well, there's some evidence of something. I mean, Justice Englander is obviously right that you can imagine a lawyer not realizing there was a 2001 trust, wasting a lot of time setting things up. And I mean, you've won some lawsuits against Attorney Delaney, so it may be right. I mean, it's some evidence, but I think isn't the more definitive evidence that no human being in the history of the world would set up a C2B4 trust and then have their will leave anything to it?
Absolutely, Your Honor.
That would be insane. And since the person who drew up this trust drew up a will at the same day, leaving everything to this trust, there is no way, whatever this is, it is not a C2B4 trust, right?
Correct, Your Honor. That was one of my other main 5 points, that the will absolutely contradicts any intent that is what Mr. Pecce.
It's impossible. It makes it impossible because you would be giving your money after you're dead. You don't need Medicaid. If you somehow have something in your estate, you are giving it to the Commonwealth when you don't have to.
So can we go back though to my question, which I'm still, I heard Judge Rubin's comment, which is that if he puts it in a trust, he didn't give it to her. I get that, although I suppose it could be done in two steps, 200,000 to her that then goes into the trust. And I don't know what the evidence actually was as to how that transfer took place. But let's back up a sec. His name is Arthur, I think. Arthur.
Albert.
Albert wants to get money to his disabled daughter that is not going to be taken by Medicaid until after she's died. And you say he can't, that this is the wrong mechanism, D4A. So what's the right mechanism? Because it seems to me that there might be a lot of fathers who might want to do that.
So, and I also want to take the opportunity to correct something I said earlier. So actually in this case, Albert Pecce put in $200,000 in 2001 and he retained a ton of other assets. And there's some discussion of this in the probate court judge's finding that if he made it through a look back period, those assets that were actually in that trust would have been non-countable from MassHealth's perspective. But anyway, I want to get to your question directly, Justice Englander. And this is, again, kind of why I think what happened with Attorney Delaney does matter, because what she did is what you would do. You would create this trust under, and you would say that I'm creating this trust under C2B4 and MassHealth Regulation 130 CMR 520.019. This is why I'm doing it, because this is a special case in which
I'm sorry, I don't mean to interrupt you, but I think you're not answering Justice Englander's question. His question was, let's say someone has a disabled daughter and wants to provide for her without her losing Medicaid. How would he do it? And isn't the answer to that simply by creating a third-party special needs trust, which he can do? It does not change her eligibility, and the money doesn't go to MassHealth at the end. Or he could create a trust just like this, a D4A, put $1 of hers in it, and put all the rest of his money in it, and still none of it goes to MassHealth, right?
Correct, Your Honor. If I misunderstood the question, yes.
But isn't it the case that if he did that, he would not be, as Judge Desmond points out, eligible for Medicaid? And the way to make himself eligible for Medicaid in the event that he wanted to be would be to put in this clause at the end.
The answer to that is very simple, Your Honor. If he had needed Medicaid in 2001 when he put this in, then he would have done it through this C2B4 type trust. To do what Justice Rubin understood the question to be is exactly right. Create a third-party supplemental needs trust, and that doesn't affect Valerie's benefits at all. Doesn't have to be paid back to MassHealth. If he creates a D4A trust, then that would only apply to Valerie's assets going into that trust.
Yeah, I have difficulty with this. It doesn't, to me, the scheme doesn't make sense, which is why I keep coming back to the question. Because I think the correct answer, and you can disabuse me if I've missed this, is he could do the other trust, but in order to protect himself against Medicaid problems, he has to include the clause that says there will be overflow to Medicaid, because otherwise and I understand your point, and I just need to say there's an easy answer to it. I understand your point that in 2001, he retained $700,000, so he wasn't eligible for Medicaid, but he could have made a decision at any point in the future to take that $700,000 and put it in there. And if he'd done that, he needed to be protected.
That part of that is correct, that yes, he could have done that at any time if that's what he was creating. But the will, the fact that the will pours over means that absolutely was not his intent. And more importantly, so if
I don't follow that at all. You mean that because he made the will, he couldn't take the $700,000, the house and whatever else he had during his lifetime and put it in the trust?
It shows that that was not his intent. A will is a testamentary document, only takes effect on death. It poured over to that trust.
Right, but he hasn't decided what he's going to do. So he creates two documents.
No, he can't. It doesn't make any sense because a C2B4 trust, which is what he would have set up to protect himself and get into Medicaid, and which is what the judge says this is, even though all over it says, I'm a D4A trust. The judge says, no, you meant C2B4. She can't be right because if you set up a C2B4 trust, unlike a D4A, you do not have your will put the money into that.
But that's different. Okay. As you can tell, we're working hard. So if you've got anything more, if it's okay with my brothers, we've kept you from making some points.
Just one statement. If he had transferred the assets to a third-party supplemental needs trust and then made it through the look-back period, those assets would be protected from Mass Health, wouldn't need any payback provisions.
Right, but the look-back period was 3 years, and that's what he was trying to, it was 3 years or 5 years? 3 years, right?
3 years according to the trust. But Your Honor, there is no evidence that that was in his frame of mind. The will contradicts it. In fact, Mass Health cites the evidence in their brief at page 18, and I put this in my footnote, which absolutely is not a finding of the probate court, and it's outrageous that they included that fact.
So this is claiming he's an alcoholic and so on. Yeah, we'll ask your sister about that. Your time has expired. Gentlemen, do you have further questions for? All right, Attorney Kobik, you're up.
Thank you, Your Honor. Good morning. May it please the court. My name is Assistant Attorney General Julie Kobik, and I represent Mass Health. The probate court correctly dismissed the petition to reform in this case because DiGiacomo did not prove by clear and convincing evidence that Mr. Pecce did not intend to include the payback provision in the 2001 trust.
Beautiful.
Now, Your Honor,
let's say we agree with you and that this should not have been reformed. It says it's a D4A trust. Why don't we just treat it as a D4A trust and you can also get nothing?
Well, I'd like to address Your Honor's premise. So the text of D4A says, if the state will receive all amounts remaining in the trust upon the death of such individual. So as I read D4A, the payback provision applies to all
I'm sorry, I read that trust funds from a third party do not go to Mass Health, do not go to Medicaid. Am I wrong about that? I thought that to the extent the trust was funded by the individual's assets, yes. But if there are funds from a third party, which is permitted, I think it's under D2, but I may be mistaken, that those do not go to Medicaid. Isn't that right?
I don't believe so, Your Honor. So the
you don't
text
say in your brief, where in your brief does it say, all you say is that maybe she wouldn't have been eligible because she was getting some benefit from it, which seems wrong to me. But you don't say that you'd be entitled to those funds under a payback provision. And your brother says you wouldn't be.
Well, we certainly do assert that this has never been a disputed issue, that we would be entitled to all the funds if 6.2 requires reimbursement to Mass Health.
Well, that's because that's not what this suit is about. And yet the judge went off on a toot, and instead of saying, I'm not reforming it, good luck, everybody, construed it to be a C2B4 trust, even though it says everywhere in it, it's a D4A. And I think you'll agree with me that if $1 of this disabled person's money had gone into the trust, along with this $200,000, it would be a valid D4A with assets of a third party, right?
I agree with that, but then Mass Health would be entitled to reimbursement for all assets in the trust.
Not from the funds of the third party. I have to look it up.
That's not what it says.
Your Honor, the text.
Receive all amounts remaining in the trust upon the death of such individual up to the amount equal to the total medical assistance paid. Language of D4A.
That's right, Your Honor. And I'd also like, so that's just the plain text of D4A. It's entitled to all amounts remaining in the trust. And then I'd also point, Your Honor, to Mass Health's regulations on this point, 130 CMR 515.001, which doesn't even have the requirement that the it be in assets of the individual. So all the other requirements for a special needs trust are the same.
Slow down. Now you're getting to the question I asked at the beginning. For a D4A trust, does the money have to come from the individual? Or could it be gifted by the parent?
So under state law, Massachusetts Mass Health's regulations, it does not have to come from the individual. That requirement is not part of Mass Health's regulations.
But don't your regulations have to be consonant with federal law? If they're not consonant with federal law, then you're not operating a Medicaid program properly. Are you suggesting to me the state law is different than the federal law on this particular issue?
Yes, Your Honor, it is. And it is, Your Honor. And so the question there would arise, does the federal law preempt state law?
Yes.
Well, actually, I'll point Your Honors, and I'm happy to submit a 16L letter on this point, but there was
not new authority.
There was recently a decision from the probate court that addressed this very issue and concluded that, in fact, there would be no preemption. But I think the main issue that I want to focus on in this case is what the dispute was actually about, which is, did DiGiacomo meet his burden to show by clear and convincing evidence that Albert made a mistake when he included the payback provision in the trust? And just as a matter of first principles, Your Honor, the question of a settler's intent is a question of fact. It's not a question of law. That's well established. And the probate court found, as a matter of fact, that Albert intended to include the payback provision in the 2001 trust. That's at page 60.
Did she reform this by reading it not as, it says, as not a D4A, but as a C2B4? Why isn't that reforming it?
So I will answer that. It requires a little bit of background, if I may, Your Honor. So what she did was she was referencing C2B4 when she was talking about the exemptions to the general rule that asset transfers count against the transferor's Medicaid eligibility when the transfer is made, unless they fall into the exceptions, right? So then they'd be subject to this 3-year look-back period. And C2 sets forth the exceptions to that general rule. And C2B4 is one of those exceptions, and it says that if there's any trust, including a D4A trust, established for the sole benefit of a person with disability who's under 65, it would fall under the exemptions to the asset transfer rules. And then the probate court put that together with a portion of the Medicaid manual that says that sole benefit requirement doesn't come into play when there's a reimbursement provision for the state. So what the court was saying was just kind of putting these provisions together. There's an exception to asset transfer rules when any trust is established for a disabled person who's under 65, so long as the state gets reimbursed first. And she made that point in service of her finding of fact that Albert had a rational reason for including the payback provision, which was to ensure his own Medicaid eligibility in 2001, because otherwise if he, yes.
No, I just found, I'm sorry, I found the part of the statute that says that only the assets of the individual have to be paid back. But I don't want to interrupt your exegesis, so I'm sorry.
Oh, well, I'm happy to take another question, Your Honor. I just wanted to say the factual finding that the probate court made was that Albert had a rational reason for including the payback provision, again, to ensure his own Medicaid eligibility. And the discussion of how this could be exempt from the general asset transfer rules was sort of supporting that factual finding, but it wasn't changing the nature of the trust. And I'd also like to point out, Your Honor, that in interpreting a trust, the probate court has the obligation to look at the whole instrument. Think about.
She construed D4A to mean C2B4. That's reformation, isn't it? How can you construe the plain language D4A to be a different phrase C2B4 without reforming it?
That's not what I read the probate court to have done. So the court looked at all of the provisions of the trust, which include many protections for Mass Health. So Article 1 and Article 12 require Mass Health's approval before any amendment to the trust
to make sure that the child's benefits aren't put in danger. all throughout, the trust couldn't be clearer about its purpose. Whether it had to be done this way to protect him or to protect her, it is clear that the purpose is to make sure that she can benefit from the trust without losing her Medicaid eligibility. That couldn't be clearer.
Without him losing his Medicaid eligibility as well.
Maybe or maybe not. It doesn't mention him or his Medicare eligibility. And the provision I'm talking about that you say doesn't apply for some reason, D2B says, in the case of a trust, the corpus of which includes assets of an individual and assets of any other person or persons. The provisions of this subsection shall apply to the portion of the trust attributable to the assets of the individual.
The provisions of the subsection.
Yeah, Your Honor,
4A. You're reading from B, right?
Subsection D, yes, treatment of trust amounts. D is a subsection.
The plain language of D4A says the contrary, so we'll have to figure that one out too on the way through.
I would point, Your Honor, to the provision that's at issue here, D4A, and again, the Medicaid, or sorry, the Mass Health regulations.
I'm sorry, what do you think D2B is cited in your brother's brief? What does it mean? It can't mean itself, because there's nothing going on in itself. It must be referring to D, right? For purposes of this subsection is used throughout this. And the subsection includes the D4 provision.
Your Honor, I'm sorry, I think it refers to D2 itself, but not D4. So
how can it refer to
because
D?
D4 also refers to this subsection. So each subsection refers to itself.
Yes, but D is a subsection.
Well,
D is a subsection, right?
I mean, I guess this is a question of Congress's intent, but each number subsection refers to the subsection. So D4 also says this subsection shall not apply. And then it talks about that subsection, which is D4. The D2 subsection refers to D2. So I think, Your Honor, the answer is to look at D4, which is the provision that's at issue here.
I'm sorry, I don't see how D2 does anything if it refers to itself, since it's just a bunch of definitions. Subject to paragraph 4, they're calling the numbers paragraphs. Subject to paragraph 4, this subsection shall apply without regard to the subsections. I mean, I can't say clearly, but it seems like it has to be D. Otherwise, it would say this paragraph.
Well, I think that would be inconsistent with D4 referring to itself as a subsection as well. But Your Honor, if I can make a broader point in response to Ms. Attorney Knudson's argument about the will pouring over,
Yes.
this court's case law is clear that a party is bound to the legal consequences of its decisions that it made when it drafted a will or it drafted a trust. So I'd cite Your Honors to the Markle case and the Loser case that are discussed in my briefs. I don't think it's open to DiGiacomo to actually contest Albert's intent in this appeal or to call it irrational or anything like that. Because
that's what the judge ruled on. The judge ruled that the intent was to make a C2B4, not a D4A. Of course he can argue that's wrong.
Well, respectfully, Your Honor, I disagree because, again, the intent of the settler is a finding of fact, and DiGiacomo did not comply with this court's rules and provide a transcript of the trial. So those factual findings would be reviewed for clear error.
Right,
and this
clear
court.
So now, let me ask you two questions. One, under what circumstances would a rational human being have their will give anything to a C2B4 trust? Why would it ever do that?
Well, respectfully, Your Honor, the question isn't the rationality of Mr. Pecce's choices, because again, that's
if we are trying to figure out his intent and whether a clear error was made in concluding that he meant C2B4, since it's non-obvious, since the trust says D4A. So if C2B4 was his intent, and there is some evidence that is so strong that it shows that that's clear error, that's fine for us. So my question to you is this: why would a rational person ever leave money to a C2B4 trust? Is there any reason?
well, so 3 points then, Your Honor. The rational reason is to ensure his own Medicaid eligibility, but the broader point.
No. His will? His will doesn't have to. He's dead. There's no Medicaid eligibility when you're dead.
Oh,
You're dead.
sure. Okay, so
why
then
would you put it? Yeah.
So my two broader points is this isn't a clear error case. So DiGiacomo can't challenge any of the probate court's factual findings as clearly erroneous because this court doesn't have the record it needs to assess whether the
I'm
findings.
sorry. We may have the record we need. We don't have a complete record, but we have something that seems like a home run to me.
Well,
and my brothers may disagree with me, but I have to tell you, I think that to me, I just don't understand. So I have a C2B4. Let me ask you this, my second question, which goes the other way. Is there any kind of trust in the world other than a C2B4 for the benefit of a disabled individual under 55, where you get the money if it didn't come from the child originally? He can set up, unless I'm mistaken, he won't have Medicaid eligibility, but he can set up a third-party, whatever it's called,
supplemental needs trust.
Third-party supplemental needs trust, where you never see a dime of the money after the child dies. It does not affect her eligibility, and it can benefit her just the same as a D4A, right?
But the
Right,
problem
and
with that is, if right off the top we've established, if he's concerned about whether he wants to get Medicaid at some time in the future, he needs to add the clause.
Okay, so
That's right.
out of whole cloth, we're supposed to believe that this guy in 2001 wanted Medicaid when there's no hint in any of these documents, and in fact, given the will, a dramatic hint that that's not what he was doing. There's no hint. We have to say, we're somehow going to construe this. Wait, oh, I know.
Didn't
It's
the lady
the
say that
one
was
where
concerned?
Mass Health, it's the one where Mass Health gets the money.
Didn't
just don't-
Delaney say that was a concern of Albert's?
In 2007,
Yes, Justice does.
2007, right?
Well, her testimony, and again, the court found as a matter of fact that he wanted to preserve his Medicaid eligibility, but yes, she testified that he could have only reformed the trust after the look back period, which I
Where
would
do you
disagree
get
with.
this alcoholic in 2001 business from? Where does that come from?
So the 2007 petition to create a new D4A trust by Delaney described Mr. Pecce as a chronic alcoholic and had gradual deterioration of.
So he had gradual deterioration 6 years later.
Well, Your Honor, I think this is precisely why the transcript matters. There are a lot of claims that DiGiacomo was making in this appeal.
Your bottom line is you win because we don't have a transcript. That's your bottom line.
No, that's not my bottom line. My bottom line is that DiGiacomo didn't meet his burden to show by clear and convincing evidence that Albert made a mistake when he included the payback provision in the 2001 trust.
All right, it seems like I may be alone here, but I just don't see it. I don't know.
Okay, but other judges have questions too, so I'm gonna.
Okay, go, I'm sorry, go ahead. And take your time, it's fine.
Yeah, I apologize. There's another issue that was attempted to be introduced late in the game. And I understand that there's a argument which has force, which is the DJ action came too late. But I am concerned that somebody's got to figure out what this language of 6.2 means at some point. And I just wanted to ask you, it looks to me to be boilerplate language, this language about states shall be reimbursed, paid and required by law to be reimbursed upon death. And your brother says, well, there wouldn't be a requirement to reimburse upon death. What am I looking at here? Can you help me at all?
Sure. Two responses, Justice Englander. So the first is you could look to the Mass Health, the state regulations, which I've pointed to 130 CMR 515.01, which again excludes the requirement that they be the assets of an individual. So that is one source of state law that requires reimbursement. And the other is a broader point, which is I think the law doesn't have to refer to a statute or regulation. It can refer to the case law on trust interpretation principles. And then again, you look at those principles and the court is required to construe the trust instrument as a whole, given the understanding.
It sounds to me like, yeah, there is an ambiguity in that language. It's going to have to be figured out what it means.
Well, it may, Your Honor, but I think that the probate court certainly, first of all, she didn't reach this claim because it was brought less than a month before trial. So this declaratory judgment claim was not ruled on.
It hasn't been reformed. If you were to accept her judgment, it hasn't been reformed, but now you have to figure out what the thing means. And you're back in another debate, it seems to me. So that's why I'm asking the question.
Well,
all right,
I'm not
sorry,
sure
I'm taking us well over time. I apologize.
Okay, your time's.
Thank you.
And we are live.
Good afternoon. Welcome to the Appeals Court. I'm Justice Rubin. I'm joined by Justices Desmond and Englander. Our final case for today is number 19-104, John Doe 28963 versus Sex Offender Registry Board. This is an impounded case, and so I remind counsel to adhere to the rules of impoundment. We are hearing argument by video conference due to the ongoing pandemic. The rules for argument, however, are the same as when we are in person at our courtroom, which is to say 15 minutes per side and no rebuttal. And with that, we will begin with Attorney Coase.
Thank you. Good afternoon, Your Honors. May it please the court, Matthew Coase on behalf of Mr. Doe. In the Doe 496501 case, the Supreme Judicial Court held that when determining that an offender must register as a level 2 offender, the board must prove 3 elements by clear and convincing evidence: that the offender is a moderate risk to sexually reoffend, that the offender is a moderate degree of sexual dangerousness, and that the public safety interest is best served by internet dissemination. Since Doe's classification decision predates the Doe 496501 case, those specific findings were not made by the hearing examiner. We think that this case falls within the group of cases where the facts of the underlying case do not clearly demonstrate that a level 2 classification is appropriate, and we ask this court to exercise its discretion to remand the case back to the board for those specific findings.
496501 is prospective, correct?
It is perspective, but Your Honor, there is the Supreme Judicial Court does say that if either the Superior Court or the Appeals Court does not feel that the facts alone justify the classification, it can, in its discretion, remand back to the board for kind of an elucidation of those factual findings.
I thought we had to exercise our discretion, and that if the findings aren't strong enough, that we can sort of say, of course, internet dissemination is warranted, that we were supposed to remand, or it's not just pure discretion, right? Or is it?
I think it's within the appellate court's discretion whether they think that the record is sufficient to keep the classification decision in place without.
Is it your position remand is necessary? Why here? Because it's an intrafamilial victim, and so notifying the public by internet may not be warranted. Is that right?
Well, I think that's part and parcel of the argument. That's one component of the argument I want to make. The first thing I do want to start off by pointing out to the court is I think that the Superior Court judge also felt in a similar way, although he wasn't familiar with the Doe 496501 case. He wrote in his decision on the motion for judgment on the pleadings, and I'm going to quote him here. He said, in the court's view, a close question has been presented whether there was sufficient articulated support for the examiner's decision that at the present time, Doe presents a moderate risk to reoffend given his age and the fact that most of his high risk and risk mitigating factors relate to an offense conduct that had occurred 26 years earlier. So what the Superior Court judge was getting to, in my view, was he was saying that this was a close call.
But that notwithstanding, Judge Lang affirmed it.
He did, but he said that he affirmed it because he felt that he was, maybe I'm saying that incorrectly, but according to the statute and the SORB cases, he's required to give deference to SORB. But I think that if he felt that perhaps—
And we are too, right?
Yes, Your Honor, you are. But allow me to kind of elaborate on the reasons why I think that Judge Lang was correct and that this is a close case, and it would be a case that would benefit from these explicit findings. So in this case, there was a total of 7 risk factors, either high risk factors or risk elevating factors. And 6 of those 7 high risk factors or risk elevating factors were taken from the offense alone, the offense that occurred 26 years prior to the hearing examiner's decision. Roughly 85% of the factors were derived from that one singular set of incidents. And with respect to those 6 factors, 2 of those the hearing examiner could not have given full weight to. With respect to factor 2, which is one of the high risk factors, under the regulations, it can't receive full aggravating weight on this fact pattern. And I'm going to come back and I'd like to address factor 2 later, because I don't think that the hearing examiner applied that factor correctly. But
Doe has been in custody since this offense, correct? Those 26 years you're talking about.
Doe has been was released from custody in January of 2015. That's in the record.
So he'd had 2 years. When was the hearing? 2017.
He had 2 hearings. The first hearing was held in 2014, and that was the hearing where Dr. Bard testified as the expert. And then in 2015, the Supreme Judicial Court issued the Doe 380-316.
Second hearing was in 17 or 18?
It was 17, October of 2017. So
if we sent this case
almost
back,
3 years
as you
ago.
suggest, would the court be limited to the record that was created in 2017, or would there be availability of additional evidence?
Well, that's not exactly clear from the 496-501 case, but I would suggest that the case law, the more broader case law on SORB cases, would suggest that SORB should look at the entire evidence, so that whatever classification.
What does the statute say with respect to his ability to seek a redetermination? Is it every 3 years?
Yes, it would be under the SORB's regulations. I think it's 803 CMR 1.31, if I'm not mistaken. So,
but the bottom line is that internet dissemination is a bell that can't be unrung.
Absolutely, and it's already there, but it is continuing harm. Yes, it can't be unrung, but the harm also perpetuates as time goes on. Now, with respect to each of those elements that the board is required to prove by clear and convincing evidence, again, there's other things. Like I said, risk factor 2 can only be given minimal weight under the regulations. You have to look at Dr. Bard's expert opinion. He did the static 99 and the MAPS 1 actuarial assessments. And he scored the lowest possible score on both of those actuarials. He got a -3 on the static 99, which puts him at a risk of reoffense at 1.2% over a period of 5 years. And that was in 2014 when he was, and now, you know, he's more advanced in his age. Dr. Bard also suggested that his lack of participation in sex offender treatment program was, he described it as a neutral factor, not risk elevating or risk mitigating, but a neutral factor. And we also have to consider that we have an individual who, at the time of the hearing, was in his late 60s, and under SORB's risk factor 803 1.33, subsection 30, an offender who is over the age of 60 must get significant mitigating weight. In fact, in the Doe 151564 case, the Supreme Judicial Court cited research that was consistent with Dr. Bard's opinion, which pegged recidivism for offenders over the age of 60 at somewhere around 2%. Now, with respect to the degree of dangerousness, I also think that the board cannot prove this by clear and convincing evidence. The hearing examiner cited 3 factors that dealt specifically with dangerousness. Some factors deal with risk of reoffense, some deal with dangerousness, and some overlap. But the 3 that he cited were factor 3, factor 8, and factor 19. Factor 19, he said that could only receive minimal weight. And then I would also suggest that factor 3 and factor 8 have a lot of overlap to them, because both of those risk factors are triggered by the victim's age. Because the victim was 5 years old at the time of his offense, SORB can apply 2 factors, factor 3 and factor 8. Now, with respect to internet dissemination, I don't think that that's a foregone conclusion either. You got to look at the circumstances of the crime. Here we have a 5-year-old child that moved into the apartment with Doe and her mother. And so there's no evidence anywhere that Doe would be inclined to offend against somebody, a random member of the public. This was an individual that was known to him, living with him at the time of the offense. And obviously we're 30 years removed from the offense, and all of these risk mitigating factors are in place.
Did you say factor 8? Did you say, I'm sorry, did you say factor 8?
Factor 8, yes, extra vulnerable victim.
Is that 8 or 18? That's 8?
I apologize, Your Honor. Let me look that up very quickly. Yes, it's 18. I misspoke. I apologize.
All right.
And then moving on, I just want to, as I mentioned, I wanted to talk briefly about factor 2. There seems to be kind of this evolving case law regarding factor 2. One of the things that the Doe 22188 case touches upon, and then there's a 128 decision that I did cite too. It seems to suggest that the hearing examiner really needs to elaborate on how much weight that they give to that factor. So factor 2 by the regulation is kind of broken down into 3 stages. So if there's more than 2 or more separate offenses, they can give it that minimal threshold weight. If there's some sort of detection of offending, then that's kind of given medium weight, and then offending after reoffense. And here the hearing examiner did not elaborate on the amount of weight that he gave to factor 2. So I would say that in and of itself, it might be cause for a remand. And it's worth pointing out that there were several other factors where he did elaborate on the amount of weight that he gave. Factor 3, factor 16.
At the hearing, there was no evidence as to what the testimony was at trial on that subject?
That's correct, Your Honor. Again, that's another issue that I raised. I don't think that the factual support can prove that there were 2 or more separate offenses. I understand what the police report says, but you have to look at his charges and his convictions. He was charged with 4 counts of rape and abuse of a child and 4 counts of indecent assault and battery.
On diverse dates.
On diverse dates. But 3 of those charges were dismissed as a result of a motion for required finding of not guilty, and he was acquitted on 1 charge of rape and abuse. And as I stated in my brief, from a legal perspective, he could have been convicted of those 4 counts for 1 single sexual act or 1 set of sexual act. So I think it's a little bit of a leap to suggest that we can trust everything that's written in this 2-page police report when some of these charges couldn't get past the Lattimore standard at trial.
What makes a set?
Well, I think when you look at SWORD's regulations in Factor 2, they talk about an instance of misconduct. And they say that there has to be kind of this opportunity for reflection in between. So I would suggest that, there might be a situation where he could have committed 2 rapes and 2 indecent assault and batteries without that requisite time for reflection as is required by the regulation.
You're on mute.
I'm sorry. Your time has expired unless there are other questions. We will hear now from your brother, Attorney Bova.
Thank you, Your Honors. May it please the court, Christopher Bova on behalf of the Sex Offender Registry Board. Attorney Coase has argued various points, and I'd just kind of like to touch upon each one and certainly listen to any questions that the panel may have. Just with respect to, I believe it was Justice Englander's question, in terms of reclassification, this case, as of October 10th, will be 3 years old. As I looked into this case, preparing for hearing today, this petitioner is eligible for reclassification as of days from today. Yeah.
And the burden would still be on SORB, right?
Based upon the Noe and the Doe et al. Cases in 2018, the burden would be on SORB. In effect, he receives a new hearing where all the evidence would be heard, and the board would have the burden to establish by clear and convincing evidence of the offender's risk of reoffense, degree of danger.
Does SORB reopen on its own?
The board does not reopen on its own, Your Honor. The petitioner does have to move for reclassification. Just to go back to the various factors that Attorney Coase had brought up in his argument, I think with respect to Doe 496501, I think the panel asked a question as to whether or not the court has the discretion. I would agree with Attorney Coase that this court does have the discretion to make that determination as to whether or not it wants to send back the case for further findings. As the board argued in its brief, we do not believe that based upon the facts and circumstances of this case, when combined with the facts and circumstances of the Doe 496501 case, that a discretionary remand is necessary based upon the specific facts of this case. Most importantly, in 496501, I would suggest that that court was dealing with a non-contact sex offender. Certainly in this particular case, you have an offender who was convicted on multiple counts of rape and abuse of a child, as well as multiple counts of indecent assault and battery.
But we also have, he's also 68 years old. The offense was 28 years ago. I mean, I'm not saying it shouldn't be disseminated by internet, but in general, my view is that the SORB itself should be allowed to make that determination explicitly. I mean, there are cases in which I've found no remand necessary because of the obvious, stranger victim on the street, pedophile who has repeat offenses and so on. But this is, a single, not that it's not horrific, it's horrific, but a single event 28 years ago in a very, I don't know how old, I think 68, I'll still call very old, although maybe this group may not feel that way. Or young.
The examiner made a finding on that issue, though, although it was fairly boilerplate, right?
Yeah, but in Doe for that is the finding, unless I'm mistaken, the finding of this warranting telling the public or something, that's made in all the cases, even 496501. It's the internet dissemination piece. Am I mistaken, Attorney Bova, that that's the new?
As I read 496501, that issue had to do with separating risk of reoffense, degree of dangerous, and the internet. Basically, how the board was writing their decisions, as this hearing examiner did before, they kind of lumped it in all in one general discussion. With the guidance of the SJC's case of 496501, the board is now breaking them up so the courts can have the ability to see specifically what the hearing exam is deciding with respect to risk of reoffense, degree of dangerous, as well as internet access.
Internet access or public dissemination?
I'm sorry?
Internet access or public dissemination?
Well, level 2 would be internet access over the board's website. Level 3s, which isn't the case here, would be active dissemination that includes internet dissemination. But that's how level 2s and level 3s break down. Just to get back very quickly to Justin Rubin's point with respect to age, I would note that age within the context of board's decisions is one of several factors. The hearing examiner did, in fact,
No, I'm not saying that the hearing examiner did anything wrong or didn't examine all of this. I'm just saying this might figure into an internet dissemination conclusion that wasn't explicitly made. So it might, so, I mean, the point of a remand, I'm not saying that on the remand that they wouldn't find internet dissemination was appropriate by clear and convincing evidence. I'm just saying, they'd have a chance to say explicitly.
If I could just respond with respect to the factor of age, which you touched upon, I don't necessarily think that the age factor in and of itself would change the hearing examiner's decision, because the hearing examiner included the age discussion within his current decision that we're
reoffense and danger. Yeah, I see what you're saying.
And still made that point. Yes.
Would they take more evidence?
I would agree with Attorney Coase in terms of it's not really settled. It really depends upon the type of remand order that the court has issued. I have had cases where the court essentially remands it for express findings only. And then there are instances where courts have remanded it for a whole hearing. And I've also had instances where hearing examiners on their own have recognized that the case may be older. And if several years have gone by, they have put out an order to the parties where they've requested that the parties update any potential evidence. So that certainly is something that can happen as well.
Because it seems to me that reading the opinion of the hearing examiner, what was animating his decision was that the Doe had been in jail for 23 years and only been out for 2. And now he's been out for 5, and that might make a difference. That's the only reason I asked the question.
Yeah. With respect to this particular argument,
he's 71.
With respect to this particular argument in this particular case, based upon this particular administrative record, time in the community that Your Honor is citing to doesn't come into play based upon this record, because at the time of the 2017 hearing, the offender had yet to been in the community for a period of 5 years.
No, I understand.
Certainly, yeah. So certainly, if the hearing examiner couldn't really ignore that fact, if it's remanded, even if no evidence was taken, because I mean, age is what age is. That the age of the offender would change.
What is the burden? What is the burden difference between a reclassification hearing and this hearing?
The overall burden is, there's no difference. The burden is on the board. However, in the Noe and the Doe et al. Cases, the August 1st, 2018 decisions that came down, the SJC did put an initial burden of production on the offender to indicate that there was some sort of change in circumstances. And then once the offender shows that initial burden of production, then the board would have the ultimate burden of persuasion to prove by clear and convincing evidence of the risk of reoffense, the degree of dangerousness, and the amount of public access.
Is 3 years in the community and 3 years of aging themselves insufficient or sufficient to meet that burden of production? Do we know?
It hasn't really played out in the courts specifically, but I would suggest that it really is case dependent because of the way the board's regulatory factors are written. So for instance, if in this particular case, the offender, and I'm going to change the ages just to make a point for Your Honor to answer the question. If this particular offender was 57 years old and had a child victim, under the board's regulations that are written, he wouldn't get full mitigating effect because he has a child victim.
I see.
If it was 3 years later and he reached that 60 threshold, then he would get full mitigating weight. Doesn't apply in this particular case, obviously, because the offender was, I think he was 65 at the time of the hearing. I think he's 68 or 69 now. So obviously he would get full mitigating weight in the hearings, and it did indeed give him full mitigating weight in the decision that we're reviewing here today. Just to touch upon briefly the factor 2 argument, I would suggest that factor 2 is a statutory high-risk factor and is indicative of a high degree of dangerousness, a high degree of risk of reoffense, even at its threshold level. Certainly, if an offender is confronted or if an offender has sexual misconduct after being charged or convicted in a court, under as Attorney Coase had indicated under the case law, the evolving case law, that even more weight would be able to be given to that particular offender. I would suggest that it still remains a statutory high-risk factor. I would suggest that if you read the hearing exam's decision, as he goes through all of the factors, there are some factors that he does give increased weight to. And under the factor 2 analysis, he doesn't give any increased weight. So I suggest that he properly understands the factor and made the appropriate analysis and didn't give any increased weight because there was no confrontation, there was no charges, no conviction. Also, with respect to the reports, I would suggest that the victim's statements to police were indeed specific and detailed. They did speak to the timing in terms of when the offense occurred, that being the time that they were staying with the petitioner, which was only a short amount of time. It's indicated in the indictments. I would suggest that the number of indictments in the dockets and the convictions also lend credence to the board's case in this particular case. And if you read Dr. Bahd's testimony and Dr. Bahd's report, I would suggest that he concedes himself that the offender's conduct was indeed repetitive. Now, certainly Dr. Bahd does have an issue with the board's definition of compulsivity, but I would suggest that the board's regulations define what compulsivity is, suggest that the case law from the SJC as well as this court is supportive of the board's definitions of compulsive behavior. And so I would suggest in terms of factor 2, there was no real error in terms of the board's application of factor 2 in this particular case.
Is there any more evidence with respect to factor 2, which is the repetitive compulsive, and the factor that deals with public place, or the fact that he could be readily discovered because the sister was in the room next door?
Not that I'm aware of. The only type of evidence that the board has would have been the victim statement, Your Honor.
The police report, you mean?
Yes, as outlined in the police report. That is correct,
That's
Your
the
Honor.
only evidence we have of what happened. There's no evidence for trial.
But I know
There
that
is
they
no
don't
evidence
really
for trial.
attack the public police.
I'm sorry, Justice Desmond, I did not catch that question. I apologize.
I note that your brother doesn't seem to hone in as much on the public place factor as he does with respect number 2. Is that because it's not the high risk factor?
I can't speak for Attorney Coase, but I do know that public place, I would suggest in terms of the hearing examiner essentially is the fact finder in this particular case, and the hearing examiner can rely on the statements made by the victim. The hearing examiner did indeed listen to what the victim said and determined that the offenses occurred when they were in the house and the mother was in the house. I note that the hearing examiner in this particular case only gave minimal elevating weight to that factor, specifically because he said it was in the house and the mother was in another room. So the hearing examiner didn't give full elevating weight to that particular factor, but did discuss the facts as outlined by the victim in the police report. And I think public place also goes to some extent to I believe it was the 128 decision that Attorney Coase has submitted most recently in terms of the remand for explicit findings. I'd just like to touch briefly on that. I would respectfully suggest that the appeals panel in that case may have been a little bit off. Public place goes to lack of impulse control. if I can say that, Justice England, I see you smirking.
You know, at this point, this panel's a little bit off too, but that's a different story.
I think I attribute it to the pandemic is what I'm going to attribute it to. So, but public place goes to lack of impulse control. And that's important because you can have a lack of impulse control, not only in a home, you can also have it out and about. And I think that the panel in that case was stuck on the fact that, well, we need to remand it for explicit findings because it was not in a public place such as a park or something like that. But that's not what the factor really goes to. The factor really goes to lack of impulse control, meaning if you can be detected, whether you're in a public park, you're in a house where there's other people, in this particular case there was, that goes to lack of impulse control. That means that when there's other people present, he still can't control himself and then offend. So I would suggest that in terms of the express findings issue, I don't think factor 16 is as much an issue as that panel relied on. And the same thing with intrafamilial victims. I don't think it was necessarily the court's intention to say that all intrafamilial victims should never go on the internet. I'd also note that in this particular case, this was a crime of opportunity where the offender's sister and the daughter moved into the apartment and they were there for a short amount of time and he took advantage of the situation. So I would suggest that based upon those, again, remand would not be necessary. And I see my time has now expired. So unless the panel has any other questions, I'll rest on my brief.